Huh.
Mentioning one SSC matter, I am a genuine candidate, rank holder 328, but my name is listed in the tendered list by the respondent.
Which list?
Tendered list, tendered candidate, so I cannot get my job. Kindly fix the matter.
This is appearing at serial number
Monthly list 960,
93.
960, 960 in the monthly list.
When you have filed it? 9/16. When you have filed it?
In the month of June, May.
May.
Yes,
Then it is prior to this notification dated 30th May, recruitment notification. What is this scope? This is not in terms of the notification. Yes, call the list.
May I have a lordship leave to mention one urgent matter, your lordship?
Please don't mention any other matter today. Yes.
One
matter. No further mentioning. Please call the list.
Item number 1.
I appear for the commission minute led by Mr. Bandopad.
No, I am appearing.
Yes, where is my order judgment? 7 July. Do you have a
শুরু করছে hand over please.
Yes. What is the matter about?
Fresh candidate. Matter.
Yes.
My case is like that. New vacancies has been included, in respect of which I have a right to participate. Now, that age election has been given to others who are participants of the 2016 selection process, not to us. This is discrimination. Second, in 2022, there was a notification which, in terms of which they are supposed to conduct selection process. At the relevant point of time, I was within the age limit. Since they were not conducting selection process, a writ petition was filed. This is the second round of writ petition. Now, in that writ petition was dismissed by your lordship, by an order.
So, according to you, all the candidates to be given age relaxation?
No.
It appears so.
No.
You are the fresh candidate.
Those who were within the age limit of as on 2022, when this advertisement was published, according to me, they are entitled to because that notification was subject matter of challenge in.
I have held in my judgment dated 7th July 2025, in spite of specific contention made on behalf of some of the petitioners, that it should be relayed back to the recruitment process of SLST 2016. I have discarded such submission. Therefore, so far this court is concerned, there is no room left open for consideration of the candidature of the fresh candidate who were within the prescribed eligibility criteria in terms of age in 2016.
So far,
yes.
So far with the vacancy of 2016 is concerned, I have no right. So far
to participate if you are eligible, but the paragraph 49 of that order dated 3rd April 2025 of the Honorable Supreme Court has made it abundantly clear that who are going to get the age relaxation. So therefore, beyond
in respect of the vacancies that was notified.
No, not at all. Not at all. That I have not held in my order dated 1st of 7th of July.
It was not even the issue in those matters,
I have not submitted. I have not stated anywhere. I have not held anywhere in my order judgment dated 7th July, in spite of making submission that this selection process should relate back or should be related to 2016 selection process. Court has accepted the new notification dated 30th of May 2025 recruitment notification, and court passed order.
Kindly see once more.
Mr. Bhattacharya, give me that judgment.
I can go through the judgment and come back, but before that, kindly take the
issue. Sorry.
Kindly hear me.
I have heard you.
No, my case has nothing to do with the judgment passed by your lordship. That is my. Kindly allow me to distinguish.
Yes.
Yes. In those cases, which your lordship has passed an order,
your sum and substance of your submission is you are the fresh candidate, and you are to be given age relaxation.
No, that's
Since you are
state-
within the prescribed limit in 2016.
No. This is not my case at all. That is not my case at all.
Age 8 kindly sees. Not kindly sees their age.
That is not my case at all.
47, 45, 40.
I am not saying that in 2016 I was eligible to allow me to vote. This is not my case. That's why I am trying to make myself clear.
Yes,
Kindly-
paragraph 3. Mr. Ahmed's paragraph 3.
Of my petition.
Yes. Yes, please read it.
This is not the pleadings.
You are seeking blanket relaxation of
Not
age,
kindly
which has
point
been
to paragraph 3 only.
in terms of the advertisement dated 30th May 2025.
Now kindly take some other paragraphs. This is not my case.
Yes, what is your case? Please tell me.
Now kindly take some the division bench judgment. Once. Page relevant page 102. And then the order of Supreme Court. Clause 11. Undertake a fresh selection process in respect of declared vacancies. I have nothing to do with the declared vacancies.
Yes.
Now, therefore, the relaxation is permissible in respect of these vacancies. So far, the participant of 2016 is concerned. Am I clear?
Division bench judgment is silent with regard to relaxation of vacancies, relaxation of age. Division bench
Division
is silent.
bench judgment
Division
speaks
bench
of-
directed that the SSC shall undertake a fresh selection process in respect of the declared
vacancies.
in this selection process, preferably within a period from the date of declaration of results, within fortnight from the date of declaration of results of the ensuing elections.
So, therefore,
Thereafter, Supreme Court,
I'm coming to that.
please you don't need not come because I have heard this matter at length. Supreme Court answered the query. Supreme Court, while concluding the issue at page in paragraph 49 of the judgment,
170.
dated 3rd April 2025, has extended the benefit of age relaxation
To the
disabled candidates as well as untented
untented.
candidates.
Now,
So where is the scope left open so far this court is concerned to go beyond that?
I am not saying so. I cannot pray for.
And which is passing through the mind of this court is this, that if you are to be given age relaxation, then all are to be given age.
I follow your assessment. That's why I'm trying to clarify my
So
position.
how you are different from other
I need
open
2
candidates?
minutes to
Yes,
clarify.
yes.
Now, paragraph 49 of the Supreme Court judgment, in fact, gives the benefit to the participant who are untented and disabled to implement the order of division bench, where the division bench says you conduct fresh selection process in respect of the declared vacancy. Therefore, so far declared vacancy of 2016 is concerned, I cannot pray for anything. Therefore, my prayer of the writ petition is nothing to do with that selection process. I have twofold of prayer in the writ petition. Conduct fresh selection process, either or allow me to participate in this selection process. This is in respect of the vacancies, which were kindly takes up once at page 129 of my writ petition. This 129 of my writ petition, kindly see last paragraph. List of indicated vacancies as received by memo dated 29 May 2025. There were these admittedly is not the declared vacancy of 2016. Now, so far the fresh vacancies are concerned, I have a right. The division bench and Supreme Court has never said anything. Now, these vacancies, in respect of these vacancies, the parties, untented candidate and the disabled will be getting benefit of relaxation of these fresh vacancies. Now, in respect of these fresh vacancies, the untented and the disabled candidate are similarly situated with me. So for declared vacancy, they have additional right. So for this fresh vacancy is concerned, that this untainted and me are similarly situated, has to be treated equally. I am
Where Supreme Court has said that in the next selection process, right of the untainted and disabled candidates would be restricted to the vacancies of 2016.
With due respect, order of Supreme Court has to be read with the order of division bench also.
Any other point, Mr.
Second point.
Yes.
Second point is, your lordship's own order is at page 112. There your lordship has recorded, which relates to the notification of 2022. This is the second round of litigation of so far these writ petitioners are concerned.
Which paragraph?
Paragraph 112.
Please tell me the paragraph of that judgment, my judgment.
Yes, second paragraph. 112, second paragraph. On behalf of the School Service Commission.
Paragraph of the my judgment, you need not indicate the page number.
Your lordship's paragraph,
Yes.
Not 7th July order.
No, I am not looking at your petition. I am on my order, judgment, you indicate the paragraph.
This is order dated 12th November 2024.
Oh, it's a different matter.
Yes.
Yes.
Because this is the first round of litigation of this writ petitioners.
Yes.
100 page 112.
Yes.
On behalf of West Bengal School Service Commission, prayer of the petitioner has been opposed on the ground that the writ petition is premature. It is submitted at present. The commission is not in a position to take steps on the basis of notice dated 5th May 2022. Since the issue relating to selection process is pending before the Supreme Court. Therefore, they could not, as on 2022, all the writ petitioner, when filed the writ petition, first round of this writ petition, were eligible. I have indicated in paragraph 3 of my writ petition.
47 years.
Now, they say because of pendency of 2016 selection process before the Supreme Court, therefore they could not conduct the selection process. Now the selection process is over. Court has righted fresh selection process. Now they are to conduct selection process. Now in fact they are conducting selection process, including the fresh vacancies in respect of which I am entitled to. Therefore, this being the second round of the petition, I am entitled to relaxation of age so far this petitioner circumstance. That is my
To the extent of vacancies which were subsequently created,
Yes,
not
only.
related to 2016 selection.
only.
That is your case.
That's all.
Issue. Writ petition is heard in the matter is heard in presence of the learned advocates representing the petitioners and representing the petitioners, West Bengal Central School Service Commission and state respondents. Stop. Mr. Bandyopadhyay, learned senior advocate representing commission, we West Bengal Central School Service Commission to within bracket for short commission করে দাও. Representing the commission appears online. Next. Petitioners, have you applied? No, you could not apply. Petitioners admittedly are overaged candidates. As a result whereof they could not offer candidature by submitting applications in terms of recruitment notification dated 30th May. Where you have annexed the recruitment notification? Recruitment notification where you have annexed?
Yes, sir. At page
122.
Recruitment notification dated 30th May 2025, being memo number 1092/7016/, CSSC capital slash ESTT slash 2025 সেন্টেন্সটা একবার পড়ো। It is submitted by Mr. Ahmed, Hamim Ahmed, learned advocate representing the petitioners, that they are not coming, submitted that petitioners are not coming either under the category of tainted or untainted as termed by the Honorable Supreme Court in the judgment dated 3rd April 2025. Passed on civil appeal arising out of special leave petition civil number 9586 of 2024 within bracket State of West Bengal versus Boishaki Bhattacharya within bracket Chatterjee close bracket and others. Stop. Stop. It is also submitted that they have no grievance relating to age benefit of age relaxation granted to the tainted to the two untainted candidates of first state level selection test 2016 for classes 9 and 10 and 11 and 12 within bracket first SLST 2016. Stop. It is further contended, it is also contended that by way of initiating press recruitment process upon issuing recruitment notification, aforesaid recruitment notification dated 30 May 2025. Appointments, recruitments are to be made not only in respect of posts earmarked for first SLST 2016, but vacancies subsequently arose are clubbed together and those vacancies will also be filled up. Next paragraph. Now, next paragraph also be filled up. Stop. It is argued that candidate termed as untainted and differently abled may have their rights, may have right originates from judgment of the Honorable Supreme Court dated 3rd April 2025 passed in Boishaki Bhattacharya Supra, but Supra relating to relaxation of age upper age limit, but their candidature will also be considered against subsequent vacancies which cropped up and notified in connection with selection process which has been initiated based on recruitment notification dated 30 May 2025. Now, it is submitted to the extent of vacancies which were not earmarked for first SLST 2016. Those candidates who will get the benefit of age relaxation whereas petitioners will not get the same benefit which offends right to equality as enshrined under Article 16 of the Constitution of India. Stop. On this premise, petitioners have attempted to make out a case that if in connection with subsequently, or if in connection with the posts which were or which occurred subsequently, in connection with the posts which occurred subsequently, those candidates will get benefit of age relaxation. In that event, present petitioners are also entitled to get benefits, identical benefit. Stop. Next paragraph. Such submission made on behalf of the petitioner, or such submission made on behalf of the petitioners is opposed by the learned advocates representing West Bengal Central School Service Commission and state respondents.
Kindly record the previous order also.
Yes.
Previous petitions order.
State respondents. Stop. It is submitted that nowhere in the judgment delivered by the Honorable Division Bench dated 22nd April 2024, as well as in the judgment of the Honorable Supreme Court dated 3rd April 2025, it was directed that recruiting authorities recruiting authority needs to restrict the selection process to the extent of vacancies which were earmarked for first SLST 2016. Stop. According to the petitioners, open to the recruiting authority to issue fresh notification, clubbing vacancies which were earmarked for first SLST 2016.
No, this is not my
as well as vacancies subsequently created.
It's not though. Blood,
Stop.
blood,
What
this
is-
not my
stop.
submission?
I am not recording your submission. Stop. What is required is to initiate fresh selection process in a time-bound manner as directed by the Honorable Supreme Court in the order dated 17th April 2025, passed on miscellaneous application number 709 of 2025, which was taken out by the West Bengal Board of Secondary Education. Stop. Steps have been taken in compliance with the directions as contained in the judgment dated 3rd April 2025 of the Honorable Supreme Court and the order dated 17th April 2025, passed on miscellaneous application, passed on aforesaid miscellaneous application. উপরে একটা আরেকটা লাইন অ্যাড করে নেবে, while advancing argument on behalf of the petitioners, যেখানে ওদের petitioner-এর argument-টা রেকর্ড করছিলাম, while advancing argument on behalf of the petitioner, reliance is also placed on the order passed by this court on 12 November 2024, passed on a writ petition being WPA 24394 of 2024 within bracket Sandeep Chakraborty and others versus the state of West Bengal. Next paragraph. This court finds substance in the submission made on behalf of the respondent authorities that that there is no requirement or submission made on behalf of the respondent authorities that it is not, or that it was not stipulated either in the judgment of the Honorable Division Bench dated 22nd April 2024 or in the judgment of the Honorable Division Bench dated 3rd April 2025, read with order, subsequent order of the Honorable Supreme Court dated 17th April 2025, that ensuing selection process is required to be restricted to the is required to be restricted to those vacancies which were earmarked for first SLST 2016. Stop. Observations made in paragraph 49 of the judgment dated 3rd April 2025 of the Honorable Supreme Court unambiguously made the situation clear that in the next round of in the coming selection process, untainted candidates and disabled candidates would get the benefit of age relaxation, notwithstanding the vacancy position. Stop. Next paragraph. Therefore, in view of aforesaid discussion, this court finds that untainted candidate and differently able and untainted candidates and differently able candidates are separate categories in connection with the selection process which has been initiated with a recruitment notification dated 30 May 2025, and petitioners herein ought not to be equated with those candidates. Stop. Therefore, if petitioners do not satisfy eligibility criteria in terms of age as prescribed in the said notification dated, as prescribed in the recruitment notification dated 30 May 2025, special 2025, no relief can be granted. Or no relief. Sentence ever poro. Test 2. Their candidature ought not to be considered. So, next paragraph, hence no relief can be granted to the petitioners. Writ petition stands dismissed. Only
one line, that this is confined to this selection process only.
Yes.
This order is confined to this selection process only because there is a prayer for seeking, conducting fresh.
Has to be.
Otherwise, there is a prayer of fresh selection process. Is not deciding that.
But this court is not required to observe this. You have to follow the Supreme Court judgment. আচ্ছা একটা জিনিস উপরে করে দেবে মিস্টার বন্দ্যোপাধ্যায় learned senior advocate representing West Bengal Central School also appears online. Mr. Kishore Dotto learned advocate general appears on behalf of the state respondents.
Your Lordship. I am deeply obliged to yours.
Item number 2.
My Lord, I am appearing for the School Service Commission, respondent number 5.
Lordship, I appear for the petitioner, my lord, and I will not repeat what transpired yesterday, my lord, but your lordship may grant indulgence to me just to place on record this order which my learned friend Mr. Uday Shankar
Please
Chattopadhyay
tell me sum and substance of your case.
Your lordship, please. When, my lord, this judgment was passed by the Honorable Supreme Court on 3rd of April,
Yes.
on that day, my lord, the intention was that those who are untainted should, in the same category, they will apply in the future vacancy. Secondly, para 49 said, which your lordship has dealt with in this, that
Yes.
certain age relaxation will be given to those candidates who had participated earlier. This is also related to item 6, which I will come later on. But as far as this case is concerned, my lord, your lordship may have this order because thereafter, after 3rd of April, on 17th of April, the estate went to the Supreme Court by filing MA number 709. And on that 709, my lord,
Oh, so much.
certain orders were passed. MA 709, my lord, simply stated to the Honorable Supreme Court saying that because this will create a lot of problem to the estate in functioning, so either the Honorable Court may permit to continue these teachers till the end of session or till fresh selection. So this was simple prayer by setting out the grievances of the estate. In the application, there was no schedule given to the Honorable Supreme Court. So Honorable Supreme Court found a midway saying that, okay, we accept your prayer, but we will give you opportunity to conclude the process by 31st of December. And that's how this order was passed. That's why this order is relevant, my lord. Your lordship may peruse that order. I'll just read.
This order, Mr. Counsel, I have seen this order.
So
What is your point? So for this
my point is, my lord,
concern,
that the Honorable Supreme Court said, directed the estate that this.
no, I am not asking you that what Honorable Supreme Court has said in the order dated 17th April 2025. I am asking you that what is your case?
My lord, it relates to that order. That's why I'll
please come straightway. What is
yes.
the case made
So,
out? So far
the Honorable Supreme Court in direction number 2 said that the examination and entire process should be concluded by 31/12/2025. So that is the deadline. By that time, a state has to conclude.
Absolutely correct.
My submission with great respect is that in the advertisement of 30th of May, the estate has given certain deadlines, certain dates that estate is free to accommodate here and there. That is my one submission. Your lordship, what transpired yesterday, I could have done it. This is my one submission over. Now, what is difficulty? Difficulty is that if I apply as general candidate, subject to outcome of this petition, these petitioner number 2 and 3 has different difficulty. Petitioner number 2 and 3 does not have 50% eligibility as per the advertisement because OBC were granted 45%. OBC could have applied in 45% eligibility.
But
now,
in view of the judgment of the Honorable Division Bench of our court,
my
now
lord,
this categorization of so far OBC is concerned has been
stayed.
set aside.
Stayed in the meanwhile. That matter is pending. Your lordship may have page 141 of this petition, my lord. That judgment is there. That order is there. It starts at page 130, and the operative para is page 141, para 16. This is on the technical ground. The estate ought to have placed the reports and the bills before the legislature for amendment or introduction of classes of schedule of 2012 Act. The executive notification are in direct conflict with the judgment, and the same had not been issued under 2012. This court had categorically observed that the judgment and it had not interfered with the executive order classifying 66 classes prior to 2010. The said judgment had not been interfered by the Honorable Supreme Court, and that such no hindrance can in conducting the recruitment process as well as the admission process taking into consideration 66 classes of OBC as existing to 2010. And in the meanwhile, Your Lordship, at next page,
What was the position with regard to classification of OBC prior to 2010 that was upheld?
that was upheld only 66 candidates, 66 classes, my lord.
Classes.
Now over the year till 2012.
So
there
if
were-
this observation of the this observation is of the honorable division bench is there,
Right.
then is there any whether this recruitment notification dated 30th May 2025 is contrary has any clause or contains any clause which is contrary to this observation?
My lord, that is not there, but the 30th of
Then where is the difficulty?
my lord, just
If there is nothing in the recruitment notification dated 30th May 2025 which offends this observation as contained in paragraph 17 of this judgment of the honorable division bench, in that event, where is the scope to interfere at this stage?
my lord, I have different problem. Problem is that I do not fall in 66 classes. I fall in the classes for which the estate had done exercise after 2010.
That has been set aside by the division bench.
Not set aside. Yes, first round
State.
set aside, and that is pending in the Honorable Supreme Court. That is
So
right now
whatever
pending in the
that
Honorable
pendency will not undo the
That's right.
order which judgment which was delivered by the honorable division bench,
That's right, my
unless
lord.
a contrary observation is made by the honorable Supreme Court.
That's right, my lord. Now, in the second round, when this exercise, which has been stayed on interim basis at page 141.
So therefore,
now
therefore,
it is
on
only
the
on technical
Mr.
ground.
Counsel,
And now what is
Mr.
happening?
Mr. Counsel, on the anvil of this judgment dated 17 June 2025 passed by the honorable division bench, at this stage there is no scope left open to the present petitioners to be treated as OBC.
My lord, the issue
So
is,
at best they can apply as a general category candidate if they comply the eligibility criteria, not in relaxation of the eligibility.
my lord, may I submit? May I submit on this? I will.
Lord, can I
ultimately leave it
interrupt
to the
for 1
Honorable
minute?
Court. Now the issue
Can I
is
interrupt for 1 minute, my lord? Then
one
think
more submission.
Yes, I will hear
everything will be
Mr.
resolved.
Bandyopadhyay. Mr. Bandyopadhyay,
Just-
I will hear you. Please,
One more
carry on.
submission. One more submission on this. My lord, this has been stayed due to some technical reason because it was not placed before a state legislature. The entire exercise has been done. Now, undisputedly, those very same people, if they belong to different region, different religion, they fall in OBC. Now, because they were added later on, that has been held to be invalid for the time being. Now, this order at 141 has also gone to the Honorable Supreme Court. My submission is, my lord, that the deadline of 31st September is for final selection. The detailed schedule is not direction of the Honorable Supreme Court. The estate can certainly accommodate, and in the process, such a huge population of this estate
No,
is
Mr.
getting ousted.
Counsel, in that event, you have to approach the Supreme Court.
My
Because
lord,
it's
now
a huge,
14
it is a huge exercise.
my lord, it has
This
been done.
selection process is a huge exercise. If I extend the time, extend the last date for submitting applications, keeping this last date of recruitment process, that is 31st December 2025, that is impossible so far the recruiting agency is concerned to complete the selection process.
I can only express my problem before your lordship. I can't
can
go
be
beyond
done?
certain limit.
What
Now
can
the
be done
issue is
today if
that
the position is
only
this?
66
There is no
classes.
quarrel there is no quarrel to the extent of observation made by the honorable division bench in the order dated in the judgment dated 17 June 2025. So far, paragraph 17 is concerned. What was the position prior to 2010 with regard to classification of 66 categories as OBC? To that extent, there is no contrary view expressed by the Honorable Supreme Court. So therefore, court has to proceed on the basis at the same time, keeping in mind the order dated 17th of April 2025 passed by the Honorable Supreme Court to conclude the selection process within certain time.
Last
therefore,
1 minute, my lord.
Please
Last-
appreciate the predicament of this court.
Last 1 minute, 2 submissions. I will not go beyond. In this process, the deadline by the Supreme Court is 31st December to complete. No detailed scheduling Supreme Court has not done. A state can still do it. Second, in this process, only 66 classes are going to be beneficiary of the entire OBC reservation, and the entire mass of this state is going to be ousted. So this equity, your lordship must consider, and a state must
Mr.
do something.
Bandyopadhyay. Yes, Mr.
State-
Bandyopadhyay.
The state must do something, my lord.
Thing is that, so for the first OBC judgment is concerned, that SLP has been filed, no stay has been granted. That is coming up expected on next Tuesday. So for the second order is concerned, that is also, my lord, SLP has been filed. That is expected to come, my lord, on also Tuesday. That's the position. Whatever, my lord, today we are working on the basis of the order of the division bench. Whatever we are working, my lord, in that order, in that matter, my lord, one contempt petition was also filed. And in the contempt petition, on 26 June 2025, an order was passed. If anybody is there, kindly hand over the order, 26 June 2005. Well, kindly read this order in 26. Content is alleged to the of the order dated 17 June to so and so passed in the writ petition so and so. Mr. Dotto, Learned Advocate General, and Mr. Bandyopadhyay, Learned Advocate, submit. They have an instruction to represent the alleged content. Let the notice be content be served on the adverse one. The so and so, not 3 is important. Kindly come to 5. Learned Advocate General Mr. Kishore Dotto has placed a notice at 21st June 2005, which is stated centralized admission portal that categorization submitted by the applicant shall not be taken for consideration for the timing and would be required to be subsequently submitted. For this said purpose, the portal would be opened afresh. It is further clarified in the notice that admission process or any finalization is subject to the outcome of pending legal proceeding, and no right shall accrue in favor of any applicant by reason of applying under the portal. The court requires the alleged contemners to put the same an affidavit, and it is expected the order, the 70 is complied with letter and spirit. Thus, the next paragraph is very important. 8. This court is of the view that the expression received all application in the centralized portal must only include the original OBC category person, that is those in the existing classes of OBCs prior to 2010 as directed by this court in the judgment passed in and so. This same must be clarified online by the state in the said portal. My lord, accordingly, my lord, an affidavit was filed before the Honorable Division Bench. Kindly hand over this affidavit, please. Anyone? Affidavit is there. Affidavit is with us, but affidavit filed. Just can I just read that? But there, in terms of the in compliance with the order of the division bench, 2 notifications have been made. In the affidavit, kindly see, that kindly come to the affidavit,
Affidavit is not there. The documents are there.
Affidavit is not there, Mr. Bandyopadhyay.
But documents are there. Documents. Your lordship, kindly see the documents.
The page which is open is part of the affidavit.
Yes.
Well, kindly see first important notice regarding category details. Having regard to the orders which may be passed in special limited so and so, filed in this honorable court arising out of judgment and order of the honorable high court at so and so.
Yes, please.
Connected. This is the subject to avoid by the
having regard, yes.
They are lordship got it. Having regard to orders dated which may be passed in special limit petition so and so, and in the honorable Supreme Court so and so, and the honorable court at so and so, order so and so, and connected writ petition for the time category details are not being collected and will be collected in due course prior to the applications being processed. Those who may have already submitted category details may be required to resubmit category details so and so. The applicant shall be notified and link will be made available to submit and modify it. This is one. Then, in terms of the order passed by the Melody in the contempt application, another notification was made. Kindly similar next notification. In terms of the order date 26 June to the recipients so and so, kindly note that the expression receipt of all application in the centralized portal must also include the original OBC category person, that is those in the existing classes of OBC prior to 2010 as directed by this court in the judgment dated 26 past in so and so. The judgment and order dated 26 so and so by the High Court in Calcutta has been challenged in the Honorable Supreme Court of India being so and so. Also, which is pending adjudication This notice is being issued without prejudice to the rights of the sworn. In terms of the earlier notice against the category, it is reiterated. But that is the point. Now the point is this, what he is praying for, that the 2012, post 2012, post 2012 notification has to be implemented according to him. But that we cannot do it at this juncture.
That cannot be done in view of the observation made by the Honorable Division Bench in paragraph 17 of
Exactly.
dated
Now,
17.
what has happened, I tell you, Lordship, what has happened when the SLP was pending, that time, we took a leave from the court to identify the OBCs for the classes. That leave was granted to us. And accordingly, Millard, the all steps were undertaken. And after that, that was placed in the Legislative Assembly. So the second round of litigation is this, that the division bench stayed that notifications also. Against that, also already we have filed the SLP. Now the position is this, Millard, when the advertisement has issued, we have acted in terms of the division bench order. There is no violation of the division bench order, and we cannot violate it. Now, if the second round of litigation, which is pending and coming up to stay, if it is stayed, let's assume it is stayed. We have to think about that. If it is not stayed, it will continue.
Even if it is stayed, Mr. Bandyopadhyay, then you have to obtain a leave from the Honorable Supreme Court. Since Honorable Supreme Court has categorically framed time by video order dated 17th.
No, I am not saying. I will not disturb that. I will not disturb that. No circumstances, this schedule cannot be disturbed.
So the SLP which has been preferred against this order dated 17 June 2025 is coming up on Wednesday.
Tuesday. It's coming up. It is expected to come today. Yesterday, the
court has to proceed, taking into consideration the last date of submitting application on Monday. So in terms of this notification dated 30th May.
I cannot do anything. I have to proceed on the basis of the notification. Until a stay is granted, I cannot do anything. And categorization, I also cannot do in view of the earlier division bench judgment.
So what I am proposing to do, that I will pass an order at the present moment, if the petitioners are coming under the purview of this, if petitioners are adjudged as an eligible candidates in terms of the notification dated 30th May 2025, they can apply. They are free to apply, but not as OBC category candidate in view of the observations made by the Honorable Division Bench in the judgment dated 17 June 2025. But I will keep this writ petition pending, and I will give directions for affidavits. In the meantime, if the situation is altered, then appropriate order is to be passed.
Millard, only 1 second, Millard.
Yes.
We are not accepting any application for the timing as on today on the basis of any category. Am I clear to you, Lord?
Category details.
Category relating to OBC. Category
Yes. No category.
This is supplementary.
only applications from all candidates.
Not even general. Not even no category now. We are concerned about. We are conscious about the
Situation which is continuing with regard to categorization of OBC. Keeping this aspect in mind, that window is kept open.
This may be recorded. This statement will resolve lot many problems. So this statement could be recorded, because this will also clarify on the issue if somebody does not have 50% and he needs to apply, then how that can be resolved, because even for OBC who is in
I will request one thing. I will request the learned senior counsel appearing for the petitioner. You should take appropriate steps with the Supreme Court.
Yes. Court is also requesting.
Matter is coming on Tuesday.
Half-minute rejoinder.
Yes.
Everything you can say on Tuesday.
I am clarifying that I am not saying that don't implement the orders of the Honorable Court. I am not saying that you are violating the orders of Honorable High Court or Supreme Court. My concern is that I also want to participate. And in that process, if you put me in certain category, ask my caste, and then you don't take 45%, then I'll be ousted. So that is my concern. And the request was that if the process is going to happen in the Honorable Supreme Court within 2 or 3 days, for that reason, if the commission or a state considers it to extend this date of 14th July to 2-3 days, that will probably clear a lot of dust from the process.
So,
So
they are
that
the
is my
OBC A
submission.
category candidates in terms of the categorization which was made after 2012.
Supplementary evidence kept in the record.
Yes, yes. Matter is heard in presence of the learned advocates representing the petitioners who appears online, and the learned advocates representing West Bengal Central School Service Commission as well as state respondents. Stop. Stop. Mr. Shamsad, learned senior advocate, appears on behalf of the petitioners, whereas Mr. Kullan Bandyopadhyay, learned senior advocate representing West Bengal Central School Service Commission, and Mr. Kishore Dotto, learned advocate general, appears on behalf of state respondents. Next paragraph. Petitioners, in effect, are seeking to be treated as OBC candidate within bracket OBC A, since previously candidates who fell under the category of petitioners were treated as OBC A category candidates. Stop. It is also stop. It is submitted that treating the petitioners as OBC candidates, if opportunity would have been extended to them to apply to offer their candidature in terms of recruitment notification dated 30 May 2025 for filling up the posts of assistant teachers. In that event, they would have received some relaxations in terms of age as well as minimum percentage of qualifying marks in graduation and post-graduation. Next slide. However, learned counsel representing the petitioners have fairly submitted that there are certain observations made by the Honorable Division Bench in the judgment dated 17 June 2025 passed on writ petitions, first one being WPA within bracket P close bracket 111 of 2025, Amol Chandra Das versus State of West Bengal and others, which may create impediments in treating the petitioners at present as OBC candidates. Stop. It is further submitted that an SLP has been preferred by the state government. By the state government, it is an SLP by the state. By the state government, and same would be heard by the Honorable Supreme Court soon. Stop.
Number SLP number
is not required. Stop. Next paragraph. Lastly, it is submitted that keeping this situation in mind, or taking note of this, taking note of aforesaid situation, petitioners may be permitted to apply as OBC candidates if necessary by extension of time. Stop. Attention of this court has been drawn to the order passed by the Honorable Supreme Court on
I'm taking lordship's leave.
miscellaneous application number 709 of 2025 in civil appeal number 580 of 2025 taken out by the West Bengal Board of Secondary Education. Drawing attention, bolam na. It is submitted that Supreme Court has fixed time schedule relating to issuance of recruitment notification and conclusion of recruitment process by 31st May 2025 and 31st December 2025 respectively, but relating to date of submission of application for offering candidature, no cut-off date has been fixed. Next paragraph. Mr. Bandyopadhyay, learned senior advocate representing West Bengal Central School Service Commission, within bracket for short commission, has made submission based on observations made by the Honorable Division Bench in the judgment dated 17 June 2025, passed in Amol Chandra Das Supra, wherein it has been it was observed in reference to the previous judgment that no interference was made relating to executive orders classifying 66 classes who come under OBC category prior to 2010. Stop. It was also recorded in paragraph 17 that the judgment, what is the date of the first judgment, Mr. Bandyopadhyay, in OBC category matters?
22/5/2024 by the High Court.
হ্যাঁ কি বলছিলাম?
22/5/2024.
Dated 22nd May 2024, delivered by the Honorable Division Bench, was not interfered with by the Honorable Supreme Court. As such, there can be no hindrance in conducting the recruitment process as well as admission process, taking into consideration 66 classes of OBCs as existing prior to 2010. Stop. It is submitted on behalf of the Commission though SLP, those special leave petition questioning judgment dated 17 June 2025 of the Honorable Division Bench is pending for consideration before the Honorable Supreme Court.
Also, the previous SLP is pending against 22/5/2000.
Supreme Court. There is no alteration of situation as discussed in paragraph 17 of the judgment of the Honorable Division Bench dated 17 June 2025 as on date. Stop. Next paragraph. It is also submitted on behalf of the Commission as well as state respondents. So far, recruitment notification dated 30th May 2025 is concerned, which has been issued in terms of the judgment of the Honorable Supreme Court dated 30 May 2025, read with subsequent order dated 17th April 2020, 3rd April 2025, read with 17th April 2025, read with order dated 17th April 2025, 3rd April, then 17th April. No categorization has been made so far. Candidates who would apply for the post of assistant teachers in government aided schools. Stop. Next paragraph. In view of taking into consideration the respective submissions made on behalf of the petitioners, commission and state respondents, as well as during pendency of the special leave petition, during pendency of the pendency of the special leave petitions, one against first judgment dated 22nd May 2024, delivered by the Honorable Division Bench, and another against judgment dated 17 June 2025 of the same Honorable Division Bench. At this stage, petitioners are at liberty to apply in terms of the said recruitment notification dated 30 May 2025 as general category candidates, provided they fulfill the eligibility criteria as stipulated in the recruitment notification, in the said recruitment notification. Top. Next paragraph, the prayer made on behalf of the petitioners to extend the time to file or to submit applications in terms of recruitment notification dated 30th May 2025 cannot be exceeded to, in view of the directions as contained in the order dated 17th April 2025 passed by the Honorable Supreme Court on miscellaneous application number 709 of 2025. So, if last date of submitting application is extended at this juncture, cascading effect would be requirement to extend time beyond 31st December 2025 in order to bring the selection process into logical conclusion. Stop. Next paragraph. However, respondent shall be at liberty to file affidavit in opposition to this writ petition by 3 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 1 week thereafter. Next. Stop. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time stipulated herein above for exchanging affidavits.
May I make a last?
Only one thing, just I clarified to your lordship.
Yes.
That your lordships have said as general category, we have not invited application on the basis of any category. Category is blank.
Yes, so this has to be recorded.
Only general, no, nothing. If your lordships
only to make application in terms of the notification.
By that side, that's it.
And secondly, the only request, last request, my lord.
Just a minute, Mr. Samsad, I will hear you. Yes. কি বলছিলাম দেখো তো? না, ওই as generated কেটে দাও। Strike it off. Yes, Mr. Samsad.
Yes, my lord. I was just making this request lastly. If your lordship may consider saying that this extension of date can be left to the estate to consider, then
Oh,
this
no,
might
Mr.
resolve. This might they will consider.
That
all
is
the
what I have
aspects.
not held in my first judgment dated 7th July.
I have seen, my lord, but
Specific,
because-
similar, identical prayer was made not by OBC A category candidates, but other group of petitioners, that Supreme Court has not fixed the last date for submitting applications, but I have discarded such submission. I cannot take a different view in the present petition.
because
I
there
have
are
to
lot
appreciate the
many
predicament of
candidates,
this
my
court.
lord. This is
Series or
serious.
matters are coming. At least court has to pass orders in sync with the previous orders.
Because of this notification, my lord, and this is serious problem relating to hundreds and thousands of candidates, my lord.
Yes, I understand.
This can
I
resolve,
understand.
my lord. The
But
estate
court
can
has-
resolve.
I understand, but court has to strike a balance. What can be done?
My lord, Mr. Samsed, I will request Mr. Samsed to make all arguments on Tuesday. Tuesday before the Supreme Court
No,
and support us.
I completely agree, and there are orders.
Thank you very much. So far, both the councils are
We have
concerned.
certain
As well as-
limitations.
My lord, I am grateful to your lordships. I am grateful.
Same issue.
They are participated in the, my lord, 2016 proceeding, but they have not, my lord, success. Failure candidates, thereafter, my lord, they apply for the 2025 application, but age relaxation.
No, that is
It's
not
not the same issue. It's not an OBC A issue.
Not OBCA.
So why you are saying same? Let it be called on one after
Same
another.
as item 1, my lord. Unsuccessful candidate seeking age relaxation.
1 and 2 is over, then 3. Call item number 3.
Item number 3.
পরে কথা বলি।
A bit voluminous petition, but I am not taking a lordship to the entire details as of now because my lord, my challenge is in 2 liens. One, probably restriction of an application due to the age, and second is my lord, a marks which should be considered at later stage. My lord, for the age relaxation, my lord, I participated in 2016 selection process. I was not selected. I challenged the selection.
Regarding which selection process?
The
You are
first,
for the state. SLST 2016? Yes.
my lord, I was not.
Who is for the commission?
My lord, I have served in my lord,
Nobody is appearing for the commission.
but then my lord, again we have to come back then.
Yes, come back.
But
Serve notice.
my lord, Lord Bill, can you take tomorrow?
Tomorrow is not possible. Application date.
My lord, I have served, and my lord, Lordship knows that the last date is.
Where is Mr. Bhattacharya? Yes, here, there. Yes, yes.
I can serve him a copy also. Una ekta copy diye dein na.
What is your case?
My lord, my case is that I participated in
Go to video once.
2016 selection process. 2016 selection process, I need not take your lordship to the High Court order, also to Supreme Court order, that has been set aside. My lord, I challenge the 2016 selection process because I say that some other candidates were given superiority and my lord, marks were not afforded properly. 2019, I filed a writ petition, and 2023 also, my lord, about your lordships. Now, some date, the my lord, Supreme Court has passed in direction, paragraph 49, which your lordship has seen, that my lord, certain age relaxation has been granted. Now, my lord, my case
You are
is that-
untainted candidates.
Yes, I am an untainted candidate because I ought to, because I have not, my lord, given rendered my service in any way. So, my lord,
Whether you are untainted
yes,
candidate
I'm
or not.
untainted. Because
Now, age relaxation is to be, how this age relaxation is to be granted, Supreme Court has not said.
absolutely,
Age relaxation is to be granted. So it is within the domain of the
absolutely.
recruiting authority.
My lord, if I make an application, my lord, so your lordship, it can come as a format for an interim order. My lord, they will consider, and if I succeed in my writ petition, because what the case I have.
So
made up-
this court has to understand that what age relaxation the court has that SSC has given.
May I take your lordship to the
If any age relaxation has not been given,
in the rules it has been given,
then
but the advertisement it doesn't specify. That is where the advertisement if it doesn't specify, if it's beyond the rules. When I will make an application, because now lordship appreciates it's all on the computers, internet. Now, at the threshold, I will be objected because they will see age 43, I will be out because the advertisement specified 40. But whereas the rule specifies that it will be in terms of para
Mr. Singh, you Mr. Singh, obtain instruction from SSC, come back tomorrow.
My
So
lord,
we have
item-
given age relaxation
item-
to those candidates
item
who are
6.
successful in 2016 selection process and are untainted.
Oh, they are unsuccessful candidates.
Lord, they are unsuccessful.
Yes, I'm unsuccessful.
So, my lord, they are
How you are
serving
you can get
themselves
the
to be
age relaxation?
unsuccessful.
I have made out a case that
I thought they are untainted candidates as termed by the Honorable
Their
Supreme Court.
services have not been
But
terminated, my lord.
unsuccessful candidates. Where is your right to get the benefit of age relaxation?
Not by the Supreme Court, probably, my lord, but the High Court has in entirety set aside. So, my lord, we go back to the position where we are in 2016. So, my lord, we are the
Come to paragraph 49
yes,
of the judgment
Yes.
of the Honorable Supreme Court dated 3rd April 2025.
yes, absolutely, my lord.
For last 5 days, I had to read it.
Yes, my lord,
I
that's why-
had to read it at least 50 times.
I-
So
I-
now you read it.
my lord, I have read it, but that
Read it, read
specifically says- that specifically
Who
says-
are the candidates who are to be granted age relaxation? Read it.
I'm skipping over the disability questions.
No. Please read it. It is irrelevant.
Disabled candidates mentioned in the previous paragraphs will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who were not specifically tainted will also be eligible to participate with appropriate age relaxation. In our opinion, such a direction would be fair and just.
It would allow these candidates, as it would allow these candidates to take part in the fresh selection
Yes.
process, which should now be initiated to fill the vacancy. So therefore, the categorization which has been made by the Honorable Supreme Court in paragraph 49 is confined to differently abled candidates as well as tainted candidates. For unsuccessful candidates, nothing has been spelled
Nothing
out.
has been said. So, we come back to
Issue.
we come back to the Honorable High Court's order.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioners participated in first state level selection test 2016.
And my lord, the
For classes-
advertisement also mentions that age relaxation will be given in terms of Supreme Court's order.
For classes 9 and 10, for classes 9 and 10 and 11 and 12. Within bracket for short first SLST 2016, first SLST for short first SLST 2016. Close bracket. But petitioners the petitioners did not but the petitioners were not declared as successful candidates. Stop. Placing reliance on the judgment dated (22nd April 2024), passed by the Honorable Division Bench on a batch of writ petitions, first one being WPA 306409 of 2016, within bracket Boishaki Bhattacharya, within bracket Chatterjee and others versus the state of West Bengal and others, as well as the judgment of the Honorable Supreme Court dated 3rd April 2025, passed on civil appeal arising out of special leave petition civil within bracket civil number 9586 of 2024, state of West Bengal versus Boishaki Bhattacharya, Chatterjee and others. It is submitted that even unsuccessful candidates, even untainted unsuccessful candidates are entitled to get
Who participated, my lord?
age relaxation. Next paragraph. Age relaxation. Stop. Next part. It is also submitted. It is also contended that petitioners. It is also contended that no provision for age relaxation is provided in the recruitment notification dated 30 May 2025, denying the right of the petitioners to offer candidature in the ensuing selection process for filling up the posts of assistant teacher. So, next paragraph. Such prayer made on behalf of the petitioners is opposed by the learned advocates representing commission and state respondents. Also, by placing reliance on the judgment of the Honorable Division Bench dated
22nd April, my lord.
dated
22nd April 2020.
22nd April 2025,
2024.
past 22nd April 2025, and the judgment of the Honorable Supreme Court dated 3rd April 2025, passed in Boishaki Bhattacharya within bracket Chatterjee Supra. Next paragraph. On conjoint reading of paragraph (363) within bracket Roman 9 and paragraph 49, or on conjoint reading of paragraph 363 Roman 9 of the judgment of the Honorable Division Bench dated 22nd April 2024 and paragraph 49 of the judgment of the Honorable Supreme Court dated 3rd April 2025, it appears no direction was given upon the recruiting authority to provide age relaxation for unsuccessful candidates who participated in first SLST 2016. So, age relaxation was only the benefit of age relaxation was only confined or was only extended to untainted candidates and differently abled candidates who were subsequently appointed in connection with the said selection process of 2016, first SLST 2016, first SLST 2016. Next paragraph. In view of aforesaid discussion, no relief can be granted to the petitioners. Writ petition stands dismissed. Urgent observation.
Only one indulgence, if I may pray for, my lord, where your lordship has
Affidavit of service filed on behalf of the petition is taken on record. Next matter, call please.
only one indulgence. If your lordship records my submission that I have stated.
Please call the next matter. Item number 4.
Number 4. My lord, before your lordship opens the brief, only one thing, it's a very voluminous. My lordship might not, my lord. I have no problem, but only one thing, my lord. Kindly, this order I am relying upon.
What is the matter about?
My lord, kindly see that is my first page. And really bottom. That is my otherwise, my lord, I will give the order with the first clear matter. My lord,
What is the matter?
My lord,
So that is not in relation to 2016.
Issue is paid. The matter is pending. I have no problem, my lord. I got
Yes. Please tell me what is the matter about.
my lord,
Yes.
my lord, we participated in the 2016 selection process. My lord, before participation, we were not allowed to participate in 2016 because we were special BA. Special BA. NCT said BA and special BA are equivalent. We approached this honorable court, my lord,
And by the order that I'm showing your lordship, your honorable court directed, no, NCT is saying special B.Ed and B.Ed are equivalent. So special B.Ed should be allowed to participate. Delhi High Court Division Bench has said that special B.Ed and B.Ed are equivalent. NCT is saying B.Ed and special B.Ed are equivalent. Now, my lord, in this notice, and some of these petitioners were also appointed. They are cancelled. Now, my lord, when they again want to fill up the online application of my lord, but the notification is saying that only B.Ed can apply. We are saying we are special B.Ed. The honorable court has already by an interim orders allowed us. The NCT is saying in an article.
Yes, what is the stand of the commission, Mr. Dr. Patra, special B.Ed?
My lord, firstly, it is not special B.Ed, it is B.Ed special education.
B.Ed special.
So this is a totally different course, different subjects, nothing, no similarity with the B.Ed. So it might be equivalent in the sense.
Where in the writ petition this qualification is stipulated? In the writ petitions?
My lord, I'm looking at
B.Ed,
the prayer.
B.Ed in education?
My lord,
Special
prayer,
B.Ed in
everywhere
education?
they have-
Or B.Ed in special education?
Yes, throughout they have mentioned, even in the prayer also they are saying so.
Yes, B.Ed special education. That is
So-
for candidates. That is for the schools which impart lessons to specially able children.
Not only that, there is a decision that each school should have a special educator. The Supreme Court decision was there.
So for that post, this qualification can be considered.
Yes, for that post only.
But not for the teachers.
Not for the teachers in general. For that, there is a separate rule. There will be a separate selection process, and there they can participate.
Yes.
My lord,
So therefore, they are not eligible to apply being a trained by treating them as a trained candidate.
my lord,
No, we will not.
Issue.
my lord, may I please the RTI information of NCT?
I am giving a direction for affidavit. Fight it out.
My lord, 14th is the last.
No, sorry, that is not within my domain. Affidavit of service filed on. Have you filed your affidavit of service?
My lord, affidavit of service and 14th.
Mr. Dasgupta, my hand is tied. What can be done?
My lord, that I understand.
17th of April, order is there.
Only one thing.
Staring at us,
No,
both of
I
us.
am not applying. My lord, I am not praying for extension, my lord, not at all. My lord, only one thing. Since a coordinate bench has already granted that in the 2016 selection process, I may participate without if ultimately if it is decided I am not. That is the only
Petitioner affidavit of service filed on behalf of the petitioners is taken on record. Next paragraph.
My lord, court fees.
Document filed in support of putting in deficit court fees, since there are more since there are
46.
46.
Check karo bolchi.
there are 146 petitioners. Are also taken on record. Next paragraph. Petitioners are desirous to offer candidature upon treating them as trained candidates on the strength of their training qualification, that is B.Ed special education. Stop. It is also submitted that in terms of recruitment notification dated 30 May 2025 issued by the West Bengal Central School Service Commission, last date of submitting such application is 14th July 2025. Therefore, petitioners as an interim measure may be permitted to submit applications for appraisal of their candidatures subject to final result of this writ petition. Next paragraph. Dr. Patro, learned advocate representing Commission, has opposed the prayer of the petitioners, and it is submitted that petitioners are not possessing training qualification which can be equated with B.Ed. With B.Ed, DLED is also
With B.Ed, only
B.Ed,
B.Ed.
B.Ed.
DLED is not
Not a-
equated
Not
with B.Ed.
acceptable for 9, 10,
B.Ed.
11, 12.
Stop. Rather, petitioners are possessing a qualification that is B.Ed special education, and same may not be treated as a requisite training qualification for consideration of the petitioners as eligible candidates in terms of their training qualification for filling up the posts of assistant teachers. Stop. While considering the prayer made on behalf of the petitioners, court is required to consider the judgment dated 3rd April 2025, delivered by the Honorable Supreme Court in special appeal arising out of special leave petition within brackets civil number 9586 of 2024 within brackets State of West Bengal versus Boishaki Bhattacharya within brackets Chatterjee and others, as well as subsequent order passed by the Honorable Supreme Court dated 17th April 2025 on a miscellaneous application being on a miscellaneous application number 709 of 2025, which was taken out by the West Bengal Board of Secondary Education. Stop. In the order dated 17th April 2025, Honorable Supreme Court has fixed a schedule, a time schedule for bringing the ensuing selection process to logical conclusion by 31st December 2025, which ought not to be tinkered with by extending the date beyond 14 July 2025 for submission of applications by eligible candidates. Stop. It needs to be taken into consideration that entire selection process is being conducted in terms of the directions as contained in the judgment of the Honorable Supreme Court dated 3rd April 2025, passed in Boishaki Bhattacharya Chatterjee Supra, read with order dated 17th April 2025. Stop. Next paragraph. In view of aforesaid discussion, at this stage, no interim relief can. At this stage, prayer of the petitioner for permitting them to participate in the selection process by submitting application is refused. Next paragraph. Let the issue be decided on exchange of affidavits. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Deeply obliged.
I will. Today I will start with your judgment, what has fallen from your lordship. That I will start with that because that is covered after going through all Supreme Court and all. So my
What you are
point
paying
is-
for?
Yes. I am untainted candidates. I have been teaching and I was there. And the thing is that when this 2025 notification came,
deficit court fee?
or I will file by the day.
Sorry, Esho. Learned advocate representing the petitioners prays for leave to file deficit court fees since 218 petitioners have joined together in this petition. Next paragraph, you are for the state.
Yes.
State respondents and West Bengal Central School Service Commission and West Bengal Board of Secondary Education are represented by learned advocate.
Lord, I will file by the
Next paragraph. A leave is granted to the learned advocate for the petitioners to put in deficit court fees by tomorrow, comma, 11 July 2025. Stop. Next, list the matter under the same heading on Monday next, comma, 14 July 2025. Next.
My lord, item 6, I appear for petitioner. This is covered matter. Your lordship has decided item 3, in which the candidates who were unsuccessful wanted age relaxation, my lord. Though in the petition it is not written, I have taken instruction. I am making this submission that this can be disposed of in terms of that order.
Item number 3, my lord. In terms
Item
of
number 3.
Unsuccessful candidate has got no right.
Yes, I agree. It was not written in the petition. I have taken oral instruction just to clarify and tell your lordship
in para 12,
outrightly
this is indicated.
that we will not waste your lordship's time.
Yes, thank you very much for fair submission which has been made. Because 2 or 3 matters back I have dismissed one writ petition
Item
on the
3.
same ground.
That's
Yes.
why I am saying item 3. It is covered by item 3.
Yes.
I was under impression that they are successful. It is not written in the petition. I spoke with the through the advocate with the
Yes.
petitioners. They were
Yes.
not successful. So this is covered under 3. Item 3.
Item 3 টা কে নিয়েছে? শুভেন্দুকে বলবে যে এটাকে সেম অর্ডার করে দিতে। So the order which has been passed in item number 3,
My
the
lord.
same order is passed in the present writ petition.
Yes. I have heard that order. These 2 petitioners had applied. They were in waiting list. So they were trying to interpret that waiting list because para 49 says others also. So that is a risky line. So I have told them that you don't have any right. You just leave it at that.
Same order as in item number 3.
I am applying for second reading.
Deeply obliged.
Yes. একটা লাইন অ্যাড করে নেবে মিস্টার সামসাদ learned senior advocate representing the petitioners appears on virtual mode and has made submissions.
Grateful,
And taken oral instruction that they were not successful.
Yes.
Deeply obliged.
Item number 7.
For the district last order.
Just a minute, Mr. This notification dated 30th May 2025 made me engage throughout the this week.
Order copy একটা রাখিস তো?
এটা রাখো, আর লাগবে না এটা মনে হয়, আজকে সব প্রাইমারি আছে পরে। ঠিক আছে, এখানে দিয়ে দাও, যখন হবে ওদের Yes, last order.
Last one. Dated, my lord,
Yes.
19th June.
Yes, yes. This one.
I'm not reading it out here.
Yes, yes, just a minute. So explain.
একটু অ্যাপিয়ারেন্স গুলো দেবেন।
দিয়েছে কিনা? কি দিয়েছে? নামটা কি দিয়েছে? SANYA নেই। ও সামনে।
Where is the order of Justice Mantha?
Lords.
Yes, I will hear you. I will hear you.
Lords.
I will hear you, Mr. Bush. Wait. Is it order dated 9 September 2024?
I get you. 9th September 2020.
Is Justice Sinha?
Justice Sinha.
This.
Yes, that means.
So you are banking upon this order?
This order and Justice Division Bench order of Justice Tandon, which was also relied upon by Justice Sinha. 9th. Oh, my lord, it is the annexure, I am told, my lord. Annexure at page. I give you lordships. Page 20. 9th September 2024.
Yes, yes. Just a minute.
One fax is wrongly recorded, but that ultimately doesn't.
Just a minute. I will hear you.
এই অর্ডারটা আমি করি এটা কোন অর্ডার পেজ মার্ক ঠিক নেই পেজ মার্ক এটা 40 হচ্ছে আবার 47 করে আবার পেজ একটু গন্ডগোল ঠিক আছে
Yes. Now, against this order, appeal was preferred.
No. And your lordship should know.
Only counsel and DI. Come to page 26 of the writ petition. In after the running paragraph, then second paragraph, then counsel is directed to consider. Then in the next paragraph, a decision with regard to grant of a scale of pay shall be taken by district inspector.
We are here concerned with A category. First one is lordship in respect of whether we will be given 6 months beach course or newly DLED course. So we are not concerned with that.
No. The page 26, second paragraph, following the directions of the honorable.
Following the direction in the matter of try to consider payer of the A category. That's we are paying.
But in this paragraph, counsel was directed. In a subsequent paragraph, DI was directed.
Because I am ultimately employee of the council, but fund comes from state.
Now I want to know from you. You have filed a report. Yes, file it. Now, Mr. Boisho, please demonstrate how the petitioners are different from the candidates who were appointed in 2021 in connection with 2009 selection process, who were granted a category scale up.
But petitioner is appointed 2025, lordship. Panel was published in 2021, lordship. But
in terms of the order of the court.
But here, lordship, 3 points is there.
So for getting an order from the court, does it disentitle a petitioner to get a category scale of pay, which was granted to other candidates who were appointed in 2021?
Lordship.
How you can make a class within the same class?
21 and 25. Appointment in the 2021 and 2025. Here, lordship. First, lordship, my judgment is a Justice Mantha judgment, lordship. I filed a report, lordship. I filed a report. Copy that. Justice Mantha order, lordship.
Page,
lordship. Justice Mantha, page 57. No, lordship. Justice Mantha order, lordship. Page 68. Page mark up. But here 50, lordship. Here, lordship. I am sorry, lordship.
The judgment starts from which page?
Page, lordship. Page, lordship. 46, lordship. 46, lordship.
No, Justice Mantha's judgment starts from page 62. Utpal Ghosh and others.
No, lordship. Kakuli Mandal, lordship.
Page 46.
Page 46, lordship.
46
Page
46 is Devas Sharma, Supreme Court judgment.
But lordship, my page 40. Akoli Mondal 60. If I'm not wrong. 46, lordship. Kindly 60. Lordship, kindly see the page 60, lordship. It is just kind of 60. Page 60 and Excel P5, lordship. 2.
Yes, page 60, Kakoli Mondal.
Lordship.
Which part you are relying upon?
Lordship, I am relying upon, lordship. Page, lordship. Page 68.
8.
Page 68. Paragraph 17, lordship. Here the petitioner shall not be entitled to claim any area or benefit, lordships. Then benefit.
Now these petitioners were appointed in terms of this order dated 25th April 2024.
Yes, lords. 2024.
Now, what court intended to direct or observe, or the purport of this observation which is made in paragraph 17 is that the petitioners would not get any area benefits. So therefore, they cannot
area or benefit, any benefit, lords.
Before the date of
letter of appointment. Yes.
Notional or monetary. No benefits.
No benefit.
Court will not. They are not praying for any notional benefit.
But
they are praying from the date of their appointment. From the date of their appointment.
Exactly. That, lordship, my point is the second point, lordship.
No. But it does not it does not demonstrate that any difference is carved out in between the petitioners and those who are appointed in 2021 in connection with the same selection process in pursuit of getting a category scale of
that lordship the benefit. That lordship I am telling you benefit lordship, but he that is not benefit any benefit lordship. A category lordship if the claim.
That is not the part of or tenor of paragraph 17.
Lordship.
Let us again read together, Mr. Boisho. All of such appointments shall be prospective and shall be issued and effective from today. From today, that is 25th April 2024. The petitioners shall not be entitled to claim any arrear or benefit.
That lordship benefit I
For
am
the
saying.
date of the letter of appointment, notional or monetary. So therefore, if I accept your submission and subsequently forget about this case, petitioners qualify or petitioners complete 6 months bridge course, they will not get the benefit.
Lordship, I coming, Lordship. That Lordship, my point, second point, Lordship, I am coming, Lordship.
No,
Lordship.
Answer the query
As
of the court.
as per my Lordship, he is not entitled to A category. Due to Lordship, come I am the second point, Lordship. Why?
Second point, yes.
Second point is this, Lordship.
Second point.
First point, second point, Lordship. Devesh Sharma case, Lordship. Come to the Devesh Sharma judgment.
I need not. You have given others. I need not.
No.
Why
I am coming. Yes, no. I am coming, Lordship, here.
In Waliar Rahman, sorry, Mr. Boisho, in Waliar Rahman, as well as in other candidates in 2021, I have given.
Rahman, Lordship, precedent is there, Lordship. Kindly see the judgment, Waliar Rahman. Justice Harish Tandon.
You have to demonstrate that how the petitioners are different.
Yes, I am
If
coming
you have
different.
given 2021, Devesh Sharma will not help you.
Yes, Devesh Sharma will help me, Lordship. Kindly see the he is in service. In Devesh Sharma say in service. Kindly see the judgment, Devesh Sharma judgment, Lordship. Kindly see the Lordship, page 64. Page, এটা কাটা আছে, এটা ঠিক আছে, 64 এ যাও, ঠিক আছে। হ্যাঁ, 64 ঠিক আছে।
Page 64 is the Kakuli Mondol.
এই তো বলছি। Which? 53, sorry, Lordship, 53.
53?
Yes, Lordship.
This is order passed in review.
Review, Lordship.
Clarification, on
Clarification. Lordship, kindly see the Lordship. 9 Lordship.
Page 53.
Page 53, 9 lines, Lordship.
Just a minute. Allow me to go through this.
Lordship.
দেখতে একদম
Read petition. Page 70. Page 70. The mantra আছে প্যারা 7. Here on that. Okay, Waliar Rahman. Waliar.
এখানে কেটে দিচ্ছি ভুল হচ্ছে তাই ওদিকে নাম্বার
দাঁড়ান
11th August 2023 is the original
order.
judgment of the original judgment in Deveshwar.
Yes, yes.
What was the judgment of Waliar Rahman?
Waliar Rahman,
Date of judgment?
Let's say,
I have annexed, I think.
but here, Lord's
10th of July.
no, Lord's Justice Harish Tandal division bench also say, Lord's in service.
30th July.
Page 34 of the report.
30th July 2024. So they how in Waliar Rahman this direction was given?
That's Lordship. Earlier, Lordship, I submit
By the
to
Honorable
Lordship.
Division Bench?
When the division bench, Supreme Court passed the order, how the division bench, Lordship, earlier that read petition I submit before that.
How
Lord.
in Waliar Rahman this benefit was?
Lordship, I'm come. Here, Lordship, kindly see the Lordship, Waliar Rahman, page,
And
paragraph
not
7.
only this, petitioners was found to be selected in connection with the selection process, but you did not give. Why you did not give appointment to the petitioners?
Petitioner is not appointed by the selection panel. Name is not their panel. Justice Banta passed the order and thereafter.
So what was the basis of giving direction to appoint the petitioners?
With the direction by the court, Lordship.
No, what was the basis?
Basis, Lordship, here somebody, Lordship, somebody claim he is the some irregularity is there. So, Lordship, justice.
Irregularities are there.
Yes.
So had there been no irregularity, in that event, petitioners would have been appointed along with other candidates in 2021.
But here, Lordship, when he is the below cut-off marks. Cut-off marks is the 11.1.
That issue is no more germane or no, is not open after the issue is decided by
We
the.
have shown
But
that
he,
the cut-off marks lesser than us were appointed. That's why.
yes, that is the, yes.
That's why they have to succumb to the judgment.
Howrah, North and Malda, that is difficulty, Lordship. There are the justice.
What is the order of order passed in Waliar Rahman?
Just
Page 20. But let's give a Lordship.
I am hearing you.
Just a paragraph 7, Lordship.
Wait,
Waliar Rahman.
wait, page
34.
Is 34 of this affidavit read petition.
My Lordship, my 57, Lordship. My report, 57 page.
Observation is in paragraph 11 in Waliar Rahman.
14, 11 to 14. That's clear.
And this order was passed, Mr. Boisho, by the Honorable Division Bench, directing them to
consider, take a decision.
Lordship, thereafter, Lordship, page 14, precedent, Lordship, only for those petitioners, those come before their Lordship. Kindly see the Lordship. The paragraph 14, this order shall not be prepared and the respondent authority to take any appropriate decision. If
No,
so,
in
what?
paragraph 13, there is a specific direction in Walia
Yes,
Rahman.
14, come to
Paragraph 13 that order impugn needs to be modified to the extent that the appellant shall be provided a category scale of pay in the same manner that of said 3, 4, 4, 6 candidates, and the authority shall take an independent decision in granting the said scale of pay.
Then
From
the
the date on which the
then 14 Lord.
which the each of the appellants are entitled. The order shall be.
Then you judgment in rem, not in rem, Lordship, or judge, no, precedent shall not be treated as precedent or a judgment in rem.
Treated as precedents. So division bench has directed in spite of Devesh Sharma.
Devesh Sharma, kindly see the Lordship, paragraph 7 of the Devesh Justice Division Bench judgment. Paragraph 7.
Yeah, petitioners were appointed in terms of the order of Justice Mantha.
This Lordship, here. Here, kindly see the paragraph 7, Lordship. Division Bench order, Lordship. Paragraph 7. Lordship, got it, Lordship, paragraph 7. My report is 57, Lord.
Now, Mr. Boisho, order passed by Honorable Justice Mantha dated 25th April 2024. That is after Devesh Sharma's judgment.
Yes.
So how they are giving a
Devesh Sharma, Lord,
without DLED?
Without, it is not my fault. It is the NCT guideline, Lord. NCT guided by the Supreme Court.
No. Question is in Devesh Sharma, as you are saying, that a cutoff date has been fixed.
1 year,
That
Lord.
is dated
March,
11th
April.
August 2023. That is the date of delivering original judgment.
Yes. 1 year.
So that is subsequently 8th of April 2024. And on 25th of April 2024, Justice Mantha passed an order.
Yes.
In spite of not having DLED qualification, having B.Ed qualification, petitioners were directed to be appointed.
But Lordship, here Lordship,
if they are appointed, while they will not get.
But when the Lordship advertisement made, 2009 advertisement made, no Lordship B.Ed is necessary.
First of all, there is an order by Justice Mantha giving direction upon the authority to appoint them. In spite of fact, petitioners are not having DLED qualification, having B.Ed qualification. Second, there is a direction by Justice Sinha directing the authorities to consider.
Yes.
Consider. Third, there is a judgment by the Honorable Division Bench in Walia Rahman.
Yes, Walia Rahman says
Gave the benefit. Walia Rahman, that is also dated 30th July 2024.
But Walia Rahman precedent not in RAM. Let's say precedent only for those petitioners, those in division bench. Let's say only for those petitioners, not for the in RAM. Kindly see the precedent and in RAM, Lordship. That's my third, Lordship. Kindly see the paragraph 7 of the Walia Rahman judgment. Kindly see the paragraph 7. Paragraph 7. In service. Paragraph 7 also, Lordship, division bench in service.
Have you preferred appeal against the order of Justice Sinha?
No. I am not favorable.
Then petitioners are similarly circumstanced.
But Lordship, 2025 he appointed, Lordship. He is the 2025. Then Lordship, I am coming.
On the date of giving appointment, whether the petitioners can be discriminated against.
But Lordship, he is in service. Devesh Sharma say in service.
Yes, in order of Justice
Or Devesh Sharma say in service. Division bench also say in service.
In order
he is not in service.
Justice Sinha's order.
2021 is in service. 2025 is not in service, Lordship. This is my submission. 2021 appointed Devesh Sharma is applicable in service. 2025 not in service. 2021 is not working in service. And Lordship, division bench also so he is not in service. My point is Devesh Sharma in service and division bench in service. those who are appointed in 2021 in service and 2025 not service, Lordship.
But Waliar Rahman judgment was also after Devesh Sharma's clarificatory order.
Yes, but he in service, Lordship. Devesh Sharma, Waliar Rahman also say, paragraph 7. Kindly see the Lordship, Devesh Sharma say, paragraph 7, Lordship. Paragraph 7. Direction appeared to be in that.
Paragraph 7 of Devesh Sharma.
No, Lordship. Paragraph 7 of the Waliar division bench.
So now this situation has been changed as it is delineated in paragraph 7 of Waliar Rahman, that there are institutions to impart training for a period of 6 months. Please read paragraph 7. You are reading.
Yes, Lordship.
Mr. Vaishyu, please read.
Yes, Lordship, I read it.
The single bench.
Teacher in service.
No, paragraph 7, please read it.
Lordship,
what was the situation in paragraph?
Single batch was considered that even there is no institution found in the state competent enough to conduct the breach course after having recognized from the NCT within a period of 8 months from the date. The appellant shall be entitled to A category scale of pay. Obviously, the reason behind the appropriate direction appeared to be that in the absence of any institution recognized by NCT, the teacher in service shall not be affected as they are entitled to A category scale of pay.
If any institution now has come.
Lordship, if the NCT, Lordship say, Lordship, Supreme Court direction by the.
You tell me what is the position in your district? Any institution has come up to impart 6 months breach course.
6 months, 2 years, Lordship, delayed course. Not 6 months. No, Lordship, if the Lordship, NCT,
all
direction for the
BA
NCT.
qualified candidate appointed in service, whatever it may be, they are getting A category scale of pay without undergoing 6 months BA course.
But here, if the Lordship NCT, here, Lordship,
Lordship,
I am not annexed here one, Lordship.
So since the petitioners are all coming from same district, that is not 24 Parganas.
Yes.
So let the DI consider the case.
That's a Lordship.
But here, Lordship,
DI or DSC for A category.
But Lordship, my submission that Lordship, here, Lordship, I am only one, so I am not annexed here, Lordship. Advertisement, I am sorry, Lordship, I am not annexed here, Lordship. Here the qualification, Lordship, Madhyamik, not for the BA. I am kindly see the Lordship, the Lordship, I am reading it, Lordship here. Lordship, here qualification, citizens of India or such nationalized declare eligible.
You are appearing for the commission. It is to be granted. You are appearing for the council.
Yes.
So it is to be granted by the government.
Who? A category.
A state government.
Yes. Yes.
So why you are?
But why am not, Lordship? I am made a party, Lordship. Is it the illegality, Lordship? They are, Lordship. So I am saying, Lordship. Why the scale, Lordship? Here the division bench says, Mr. Sharma in service, division bench and in service.
First of all, in a similar situation, Justice Sinha has passed an order. Division bench has passed an order in Waliar Rahman. Even after the cut-off date fixed in Devesh Sharma's clarification order.
I think I should clarify your lordships. They are always saying Devesh Sharma right now in this case.
Yes.
Devesh Sharma was in a different context. I tell you lordships why. Devesh Sharma, while the teachers were recruited, they were recruited with B.Ed qualification. Now, B.Ed qualification notification was quashed by the Supreme Court as unconstitutional on 11th March 2023. Therefore, in the meantime, they were recruited. Now, the question, Kamlad, according to the settled law, judgment will be retrospective. Therefore, they will be out of service. Then clarificatory application was moved. Then Supreme Court says those who have made appointed in the meantime, they are saved. They are saved.
But your appointment is after that cutoff date.
No, there is no after.
Yes.
I get your loss. I answer to that. Therefore, Devesh Sharma, strictly speaking, doesn't govern me. I tell you, loss is why. Therefore, those appointed candidates are
11th of August 2023 is the original order passed in Devesh Sharma.
Devesh Sharma. Here, kindly also consider what was the subject matter in SLP. 18th, 28th June 2018 notification of NCT entitling DLED candidates or making eligible the B.Ed candidates. That was
June 18 June
28th June 2018. That's notification making the B.Ed candidate eligible. This is a pan-India notification. That was questioned before the Supreme Court. 11th March 2024, Supreme Court quashed the notification.
2024.
2023. 2023. Resultant effect judgment should be retrospective from 18.
So all B.Ed candidates appointments should go.
Then, my lord, the clarification application was moved. Then, my lord, on clarificatory application, Supreme Court saved those appointments. But our selection, your lawsuits in 2014, appointments are not given. No training.
Selection appointment to different things.
Coming. That's not right now. But we did, no training qualification was required. When 20 panel was approved by the order of the Honorable Justice Tapobroto Chakraborty, then panel was found several discrepancies. Then we are not in the panel. 21 panel candidates were appointed in 2021, 24. We came up before this court, pointed out illegalities that even the candidates who have secured less marks than us have been appointed. Then court said, Justice Manta's order losses will find that either will quash everything or whosoever come up with this cut-off date, they should be given appointment. They succumbed to this, appointed us also in 2025. Now, in the meantime, your losses, those who are appointed with B.Ed qualification 2021
from the same panel,
same panel,
or in connection with the same selection process.
Same selection process, same panel. They came up before Justice Sinha. Justice Sinha took the logical view of those judgments that if the B.Ed candidates appointed in those cases have to undergo 6 months course and they should be regularized, why will you not do this? In Justice Sinha's matter, my lord, I moved it. My prayer was that either you allow me to go to DLED course or give me 6 months bridge course. Their stand, I will not allow you to go to the DLED course. I will show the report. Commissioner said they can only be given chance to 6 months bridge course. Kindly have a look at this report. Mr. Dotto appeared. Only the last paragraph. Then I said, okay, because I have to go to be trained. Okay. Then, your lordships, our prayer also a category. Kindly have a look at the last paragraph of the report submitted by Mr. Doctor through commission. Kindly see. Page number 5, last paragraph. Because we had to be trained, treated as trained. 7. In accordance with the aforesaid notification of NCT and judgment of the Honorable Supreme Court of India, it is stated that there is no such provision for the in-service teachers appointed with B.Ed qualifications to undergo 2 years DLED course after the commencement of the RTF to design. They have to undergo the bridge course to be designed by the NCT. Justice Sinha accepted it. That you look.
So only bridge course was left open.
Left open.
Now there is no nothing.
As of today, those candidates
we should facilitate these candidates to
complete
6
Then
months.
Justice Sinha said you have to give them A categories. They have bid it, and this basis report Justice Sinha order was passed. Now 2021, those appointed in this situation they are A category. How could my learned friend make a distinction?
Differentiate.
Supreme Court. What is the distinction? In name, all name, nothing, my lord.
Distinction only for the 20. Devesh Sharma effect from the 2023.
And I said Devesh Sharma is not applicable in the fact situation.
Because Mr. Boisho and Mr. Dotto, this selection process started in 2009.
Yes.
And the B.Ed was a valid qualification at that point of time.
No qualification required.
No, Madhyamik, only for Madhyamik, only for Madhyamik, no B.Ed necessary.
Petitioners are B.Ed candidates. They participated. But because of the
On date
irregularities
2009, Lord,
the selection process, they were not appointed along with other batch of candidates who were appointed in 2022. In 2021.
the below cut of marks,
Now,
we are not appointed.
now they were not appointed. They filed a writ petitions. In the writ petition, Justice Mantha said that it is found that there are irregularities.
Justice Abhijit Ganguly, first Abhijit
There are
Ganguly said they are
irregularities
after
because the
Mantha.
candidates who are who obtain marks below the
cut of marks,
below the cut of marks, they are appointed. Either appoint them who have
all
approached or enter selection process.
selection
to be
procedure
cancelled.
was.
Then you succumb to the to that proposal, and ultimately they were appointed. So the delay which has been made in appointing the petitioner is not attributable to the
But
petitioner.
let's see if the petitioner,
if there would have been a fair selection process, they would have been appointed in 2021.
Well, only this time my learned friend could have argued before losses had they not given the benefit of A category scale of pay to candidates appointed in 2021. If they
Mr.
should have,
Sannal, file a short reply
to
their
we
opposition.
accept this report. Accept this report.
That will be on record.
That's my legal
but Lordship,
argument.
my only Lordship here, my Lordship 2 point is there.
If your lordship requires
If
that, I
the-
can give a submission.
Lordship, if the Lordship Devesh Sharma, my landed friend Devesh Sharma not necessary. So why the justice division bench and single bench pass the order on the basis of the Devesh Sharma? Lordship, A category of the scale of pay. Lordship 2020 government jack na, আমি DPC হয় government ও বলবে। Every time Mr. Ratul say government jabe. Then Lordship government says I am the DPSC by council appointed me. I am on behalf of the council. If the government say yes, so yeah, every time Ratul criticize, yes, government galo.
You make
That
your
or why
submission. Don't
remark
lay
this
your
type
ears
of-
to others to make your submission.
But that Lordship, my submission is Lordship, 20 panel was prepared 2021, panel 1 after 1 year, panel is left as per the Lordship Supreme Court order. But Justice Mantha or any judges pass the order, give me appointment has been given. My submission is Devesh Sharma only for 2023 prior to that Lordship Mike.
Then how Justice Sinha passed an order in 2024?
Their Lordship, their
accepted order and the benefit.
no, there were division bench say, where the division bench Walia say in service. Walia also kind of paragraph 7. Paragraph 7.
Court will not follow the order of Justice Sinha.
I am when the division bench order is here, Lord,
Did not say anything contrary to the order.
only for the in those who are coming.
And in other hundreds of matters, I am also passing.
Yes,
order
yes,
directing the
2021.
commission, relying upon
Yes,
relying upon
2021
Wali
Lordship.
Ahmad to take decision.
2021
As
panel.
judging my lord, before appointment I cannot.
2021 Lordship passed the order, usual order passed 2021, those who are appointed, not for the 2025. That is my appeal. Those were the commissioner say, I am not, if the Lord,
If there would have been a fair selection process, they would have been appointed in 2021.
no, where is the fair election? If the Lord say, I am on the behalf of the DPSC, if the Lord say, just if on that time, Lord say, I say, Justice Mantha, the state and Lord say, DPSC consent order has been passed. But I am not giving any consent. If the Lord say, which passed, then Lord say, what can I do? Lord say, I am not prefer an appeal, but my.
This, may I, my lord, in my own way? Lord, here Lordship has heard, my lord, both Mr. Sannal and Mr. Bhargava. My lord, here, my lord, the crux of the matter is the date of appointment of the petitioners. Because Lordship kindly sees, I mean,
His petitioner was appointed in 2025.
Lordship. Now, my lord, the appointment letter is very important, if I may place. My lord, this is, if I may place the appointment letter once, my lord. Lordship, kindly have a look to, my lord, in my petition, my lord, it is page 22. Page 22, I said. You have to put the
Page
21.
Maybe 21, 20, in my, this is 6th of March 2025. Lordship, my lord, ঠিক আছে. Lordship, my lord, may I place this?
Last paragraph.
Yes. This order for appointment is issued in compliance with the order of the Honorable Calcutta High Court passed on 25th of April 2024. Read with order dated 30th of April 24 passed in WPA number so-and-so with CAN number so-and-so along with other connected applications and video Commissioner of School Education memo number so-and-so dated 27th February 2025. Lordship, my lord, got it, my lord? So, my lord, just pausing here for a moment. My lord, this appointment letter has been issued acting upon the order of my Lord Justice Mantha, where paragraph 17 puts some restrictions. So, my lord, they he or the group of petitions are here. Next page, you will also find the joining report.
No, the next page is page 9, order of this court.
But I am in 3 matters, but in this
Very well,
matter.
this is the appointment letter, then joint.
Yeah, then
6th
joint.
of March 2025, very well.
Malad, here what I am submitting, Malad, this, the paragraph 17 is very clear of Justice Mantha's order. Malad, if I may show to your lordship, Malad, this Mantha's order, Malad, page 24 once again. There, Malad, it is very clear.
Just a minute. 24th April 2024.
Yes.
25th April. Kakuli Mondol.
Yes.
Kakuli
Mondol, yes.
Yes.
Lordship.
Paragraph 17.
Yes. I think it is in the report they have annexed. I have got a copy from them. This is Malad, this, yes. Page 64, it starts from 64.
Page 68.
Lordship. Lordship, if I may place once again. All of such appointments shall be prospective. No, paragraph 16 I place first. After verification of records, writ petitioners and added parties shall be accommodated and given letters of appointment. If the vacancies are exhausted, the DPSC North Central Parganas shall publish a list of waitlisted candidates. Such panel of waitlisted candidates shall be kept alive until vacancies continue and arise and all the petitioners are appointed. Then all of such appointments shall be prospective and shall be issued and effective from today. That is the date of the judgment of Justice Mantha. The petitioner shall not be entitled to claim any arrears or benefits before the date of the letter of appointment, notional or monetary. So the letter of appointment is a very vital thing. Now, my lord, by accepting the appointment without any demur or objection, my lord, they have joined the services. So their services have to be counted from the date of appointment. Now, my lord, they
cannot pray for notional benefit.
Yes.
Or actual.
And Malad, they have, in my humble servant, they have consciously abandoned the known rights, if any. I claim that we were selection process, we are in the selection process 2009, someone were appointed 2001, all they have foregone. They cannot now resuscitate that particular claim after accepting the letter of appointment. And they have joined without any demur or objection or without prejudice that we normally do or advise the litigants to do. Here, my lord, after accepting the letter of appointment, acting upon the order of Justice Mantha, they cannot now claim the benefits, if any, prior to the date of appointment. And my lord, the Devesh Sharma judgment, my lord,
23rd of August 2023.
2023 is the original judgment.
Just a minute.
Original judgment, yes.
No, it has been referred, it has been discussed in the subsequent judgment also.
Yes. Yes, my lord, original judgment is, my lord, this is 11th August 2023. My lord, this judgment is also relevant.
Just a minute. Devesh Sharma judgment, you have annexed in your report.
Yes,
His report.
Page also 51.
My lordship, kindly.
50.
What the this is ball?
That's a 50.
The internal page, the clarificatory order.
Just a minute. Just now it has been shown to
49.
59, 50.
Which paragraph?
Oh, this is a repeat. Sorry.
46.
The last document of the report.
Yes, page 46. It starts. Just a minute.
Lordship, I just paste only.
Page 53.
Yes.
The date is 11th August 2023.
Lordship. Your lordship comes to the internal page 7.
At page 52.
At page possibly 52.
Yes.
Lordship, I just place it. In the given facts, we find that the question as to whether the prospective or not.
Second paragraph.
Second paragraph.
7.
Yes, second paragraph, internal page 7 of the clarificatory.
Yes, in the given facts.
In the given facts, we find that the question as to whether the judgment would be prospective or not was not stated by us in the judgment delivered on 11th August 2023. Ordinarily, a judgment acts retrospectively unless it is specifically stated to be otherwise. Moreover, this matter has been heard on several occasions and the points urged by the respective parties have been taken note of by us. As it appears that a large number of candidates with BA degree had already been appointed on the basis of eligibility criteria specified by the educational authorities, we do not think it to be equitable to effect their removal. We accordingly hold that the judgment delivered by this bench on 11th August 23 shall have prospective operation. But prospective operation of this judgment shall be only, this is very important, only emphasis for those candidates who were appointed without any qualification or conditions imposed by any court of law to the effect that that appointment would be subject to final outcome of each case of the case which might have had been instituted by them and such candidates were in regular employment without any disqualification and were appointed in pursuance of a notice of advertisement with B.Ed as stipulated to be valid qualification. Services of only such candidates, again the emphasis applied here, shall not be disturbed. Because of this judgment, we make it clear that this benefit is only again for the candidates who were appointed prior to date of judgment was delivered on the 11th of August 2023. Mere selection of such candidates or their participation in the process. Lordship, kindly, this is the very important part. Something, it is a dead issue by the Supreme Court judge, is very clear. Mere selection of such candidates or their participation in the process. Mr. Sandal's clients are claiming benefit from their participation in the process. That has been set at now by the Supreme Court. It has been settled for all time to come. Will not entitle them for a benefit under our present order. Then
now here pausing here, what I'm asking you, I want a clarification.
Lordship.
That after 11th August 2023, if any teachers are appointed with B.Ed qualification,
Lordship,
they have not been given a credit scale of pay.
Now, my lord, Lordship, kindly.
No, I want this answer first. I'll go on later. This is the relevant part.
This is in the judgment. Next paragraph.
My lord,
only for those appointees who has been engaged in these conditions.
That I want. What is the present situation in the state?
My lord, the cut-off date is 23rd.
Please tell me, Mr. Dotto and Mr. Boisho, that yes, they were appointed without making any demand. So now they cannot.
They have accepted it. They accepted.
We can't.
Yes.
But that doesn't. But at the same time, here we make it clear that this benefit is only for the candidates who were appointed prior to the date of our judgment was delivered on 11th August 2023.
So mere
selection of such candidates or their participation in the process will not entitle them to the benefit under the present order. Now I am asking you that any candidate without or any candidate possessing B.Ed qualification, not DLED, whether granted a credit scale of pay.
Yes, Rahman.
Lordship, they are trying to revive a date claim by presenting this petition before Lordship because of their acceptance of the letter acting upon the order of Justice Mantha.
Now, if you
they cannot look back.
If you go back to the order passed in Waliar Rahman.
Well, that is the judgment in personam. Well, if I may place the next paragraph for
yes, please let us come to the judgment, the order of the division bench in Waliar Rahman.
This
come to page 37 of the writ petition.
37 number mill.
Yes, Mr. Boisho, give a copy of this.
No, konta.
Waliar Rahman ta thakko.
Well, the amake jara.
Please read paragraph 11 of Waliar Rahman, page 37.
Well, the position, well, before I read, one thing, this is the judgment in personam. Please read it. The position as it stands today is that 3,446 candidates who stand on the same footing that of the appellants are getting A category scale of pay, despite having not undergone the 6 months breach course, and therefore it is evident and apparent from the conduct of the authorities that the appellants standing on the same footing is inflicted with the act of discrimination offending Article 14 of the Constitution of India. Though the wise mind has awakened the situation after the direction was passed by this court, yet it has not seen the ultimate destination, and it would be injustice to the appellants if they are denied this similar treatment with those who stand on the same footing. Well, I was here for a moment also. Well, they are not, the petitioners are not similarly placed like these courts,
3,446 candidates, they all were appointed prior to this cutoff date as indicated in the judgment of Devesh Sharma.
No, that
That is on 11th, before 11th of August 2023. That I want to know from 2024. When the division bench can pass order on a special situation, this court can also pass an order on special situation. So therefore, what I want to know, whether these 3, 4, 4, 6 candidates were appointed prior to the cutoff date of 28 June 2018.
Well, I'm not sure about it.
You will take instruction.
I'm not sure about it. But Malad, what has been stated here?
No. Say, straightway, please come to the query of this court.
Yes.
Otherwise, it will be a never-ending process.
Malad, the Lordship kindly sees, Malad, this 6 months breach courts that emanates from the judgment of the Honorable Supreme Court only to accommodate those left out.
Very well, Mr. Dotto file an affidavit, 2 pages affidavit, indicating whether any candidate who was appointed after
11th August 2023.
After 11th August.
After 11th August 2023
has been given
as primary teacher with B.Ed qualification has been given academic scale of pay or not in the state. File an affidavit. I will direct the commissioner to file an affidavit. Let me see what is the position.
But the appointing authorities are the different. The council is the appointing authority.
Authority is the state.
Yes, that is true. But the appointments are given by the council.
Let us are hard together in presence of the learned advocates representing the petitioners, not 24 Parganas District Primary King Council and state responses. Next paragraph. In consideration of the submissions made on behalf of the parties, it appears that VDA judgment dated 8 April 2024 passed in miscellaneous application diary number 4303 of 2024 within bracket Devesh Sharma versus Union of India and others. It was observed by the Honorable Supreme Court. Only the candidates were appointed prior to the date of the judgment delivered on 11th August 2023 shall be granted benefit. Though those candidates were possessing B.Ed qualification. Stop. It was also observed that mere selection of such candidates or their participation in the process would not entitle them for a benefit under the order passed by the Honorable Supreme Court on 8 April 2024. Next paragraph. At the same time, on behalf of the petitioners, attention of this court has been drawn to the relevant part. Attention of this court has been drawn to paragraph 11 of the judgment dated 30 July 2024 passed on an intra-court appeal being MAT 1038 of 2024 within bracket Waliar Rahman, page Waliar Rahman and others versus the state of West Bengal and others, where in it was recorded three, 446 candidate who were possessing B.Ed qualification were getting A category scale of pay. Stop. Commissioner of School Education, West Bengal, is directed to file a report in the form of affidavit disclosing whether any candidate who was appointed after 11th August 2023 having or possessing possessing B.Ed qualification is granted A category scale of pay or not. Stop. Let such affidavit be filed. Let such report be filed by fortnight from date.
It is difficult, Malad. So many candidates. Malad, the appointing authority is the what is called.
That report, only one report has been filed.
Yes, in one matter report is to be filed, not in other. In one matter, not in other matter.
Malad, this data.
In the lead matter, a report is to be filed. I am directing the government bidder to regularize your engagement.
No, I am there in 2-3 matters. I am
in
there.
the lead matter.
Yes.
Yes. We filed by fortnight from date. Do you want another week time?
At least 4 weeks time be given to us.
Well, I will take it.
It is not that.
Take it up after coming back from circuit. So you will get some time. Just a minute. Very well. By 4 weeks from date. By 4 weeks from date. Next paragraph. List the matters under the same heading on 7th August 2025. Next paragraph. Learned government bidder is requested to engage to regularize engagement of Mr. Dotto, Mr. Swapon Dotto, learned additional government bidder on behalf of the state respondents in WPA 12116 of 2025, along with a junior of his choice.
Junior is held, already junior is.
Stop.
Yeah, they are here.
Yes. Let me see.
Lordship, recess, lordship, lot.
You take it back. Mr. Sannal, in the meantime, do you want to file leave is granted to the petitioner in WPA 12116 of 2025 to file an affidavit taking exception to the report filed on behalf of District Primary School Council, not 24 Parganas, before the next date of hearing.
Up to 95.
তুমি ওইটা বাদ দিয়ে সবকটা করে দেবে, এটা ডাকবে, আলাদা করে অর্ডার আমি এসে করে দেবো।
Up to 95 similar matters.
Only item number 16.
16 and 56.
56 is 16 is disposed of matter wrongly. It has been in.
Particular matter. 95 matters আছে।
হ্যাঁ, সব উইথ করি।
দাঁড়াও,
হ্যাঁ, কম্পোজিট। Next paragraph, it is made clear that this order is not passed in bolo item number
16, my lord.
first bolo 16 16 in WPA 12269 of 2025 within bracket Muhammad Azad alias Muhammad Azad versus the Kolkata Municipal Corporation and other versus Kolkata Municipal Corporation and others. So the yellow and item number and writ petition being WPA being WPA 13146 of 2025 within bracket Sushanto Shikari versus the state of West Bengal. Sushanto Shikari versus state of West Bengal and others. Stop. What is the matter about Sushanto Shikari? Primary matter. Stop. Let this matter be taken up separately. Let this the writ petition being WPA 13146 of 2025 shall appear in the list under the heading primary motion on Tuesday next, 17 Tuesday next, 15 July 2025. Stop. 16 take disposed of matter. Stop. The writ petition being WPA 12269 of 2025 shall go out of list since the writ petition was disposed of previously.
Up to 95 identical matter, lordship, what are the same order?
On the same order. How many orders is to be?
No, only same order.
Why you are mentioning?
Item number 7 has
Yes.
164. And last time it has 95.
No, it's not possible. In the first item number 7, the order was passed. In other matters, it will appear on 7th of August. No order is passed. Yes, please call the next.
Without our name.
No, I have not passed any order. Only in the first matter, I have passed order.
Yes.
What can be done?
As your lordship.
Because on so many matters, one order cannot be passed. It's a difficulty in transcribing the order. If ultimately first matter is disposed of, then this order will cover other matters. Yes, yes.
As your lordship.
Yes.
Item number 96.
And I'm for the state respondent.
Has been decided by your lordship against us. This is pertains to 2009 selection process.
So that cut-off date,
Yes.
24th of April.
5th of April.
5th of It is from Malda.
Yes.
তার অর্ডার হবে 7 নম্বর আইটেম অর্ডার তাহলে এটাকে রাইটার করে রেখে দিলাম
ये तो फर्स्ट मैटर
already
রিমার্কস বাকি তো 95 অবধি আমাকে দিতে হবে সব কম্পিউটারে করবি না শুধু 7 16 56
In the present case, when you have filed, just a minute, 29th April 2025.
এখানে লিখে দিতে হবে তলায় লিখতে হবে অলরেডি ডিসপোজড বাইও করে
আমরা তো
You are not the impanel candidates.
None of the candidates who have been appointed subsequently were impaneled.
Even those who were appointed in terms of the order passed on 25th of April 2020.
Those were
All.
not impaneled candidates.
Yes, same order. এটা দেখে করে দিন।
And Alota, let the Supreme Court order be also taken out because it was challenged before the Supreme Court in SLP. And
When it was passed by the Honorable
So withdrawn, Malay.
it was withdrawn.
Because
Then my lord's order has reached its finality.
Oh, against my order?
Yes, directly to the. No.
SLP was withdrawn, Malay.
They have not placed this.
Data?
16th of May.
এসো এইখানে এটা অ্যাড করবে, বুঝতে পেরেছো? Moreover, order passed by this court on a writ petition being WPS 7327 of 2025 within bracket MST Y the Rahman and others versus the state of West Bengal and others was questioned before the Honorable Supreme Court in special leave to appeal C number S 13596 of 2025. Stop. Special leave petition was dismissed by the Honorable Supreme Court, video order dated 16th May 2025. Taking note of the submission made on behalf of the appellants, taking note of the submissions made on behalf of the petitioners, seeking permission to withdraw the said special leave petition. Stop. Copy of the order dated 16 May 2025 passed by the Honorable Supreme Court. Please take it on.
I'm grateful.
এইটা এখানে অ্যাড করে দেবে, দিয়ে তারপরে বাকিটা ডিসকাশন।
Paid the deficit.
আচ্ছা, উপরে একটা প্যারাগ্রাফ অ্যাড করবে, এরপরে এখানে অ্যাড করবে ডকুমেন্ট ফাইলড ইন সাপোর্ট অফ পুটিং ইন ডেফিসিট কোর্ট ফি ইজ টেকেন অন রেকর্ড।
I'm good.
নেক্সট
কোর্ট ফি আছে আইটেম নাম্বার 97
ইয়েস just a minute. Status of the Yes. What is the present position?
Clearly stated that the petitioner applied and
Widow daughter.
yes.
So let the PPO be issued. All steps are taken. Issue. Learned advocate representing the state respondents has filed a report dated 7th July 2025 and same is taken on record. Next paragraph. On perusal of a report dated 7th July 2025, it appears that petitioner applied for family pension being widow daughter on 7th April 2025 and subsequently attended the office of the District Inspector of Schools PE Purbo Medinipur, being respondent number 4 on 25th June 2025 and submitted legal age certificate and also put signature in the pension booklet. Stop. After compliance of necessary formalities and making the pension papers ready, pension case ready, pension case of the petitioner was forwarded to the Directorate of Pension Provident Fund and Group Insurance, Kolkata, on 3rd July 2025. Vide memo dated 26 June 2025. Stop. From the report dated 7 July 2025, it also appears that at present pension case is pending before the Director of Pension Provident Fund and Group Insurance, being respondent number 2. Next paragraph. In view of aforesaid situation, respondent number 2 is directed to issue pension payment order on compliance of necessary formalities by 4 weeks from the date of communication of this order. Stop. Respondents are further directed to release family pension in favor of the petitioner at an early date, but not later than 8 weeks or 10 weeks from the date of communication of this order. Writ petition stands disposed of. Urgent Xerox certificate. Next. Yes, I have recorded.
Item number 98.
Yeah.
Your lordship direction, I served the notice.
Where is Mr. Chattopadhyay or Shahabuddin Sardar or Ujani Pal? Where else? Have a notice not today. Inform Mr. Chattopadhyay not today. Next.
Not today. I'll tell you.
Next.
Item number 99.
For the petitioner.
For the state.
The petitioner.
Yes.
The petitioner is a primary school teacher, my lord. She completed the DLED course in 16-18 batch. But while she was pursuing, my lord, at that point of time, she was appointed as untrained. Now, after receiving the trained certificate, my lord, she submitted before the authority has granted her a category scale of. Today, my lord, my only prayer is that, my lord, to update the database of the board, to treat me as the trained candidate. This is the only prayer
I have passed order in certain other matters, Mr. Chu.
Download the order because it is showing in the server, but it cannot be downloaded.
Similar situation.
Lordship, 9329
এই বার করতে বলো তো অর্ডারটা
9329.
9329.
It is open in my mobile also, but I can open the order also. 9329.
Yes, I have the order.
You have the copy? Yes. No, no.
Not
Hard
print-
copy.
Not hard copy. 9329 of 2023.
Wait a minute.
Print করা হয়। Print করা হয়।
2016-18 session.
Yes.
And this order is of 14.
Your contention was that at the time of selection process, he appeared as untrained candidate.
And with the untrained panel only they got.
But I have discarded your submission and directed that
Change lordship. Order lordship. Initially lordship was against last lordship.
Paragraph 7 you got.
but a list was published there showing that breakup of scores where the column which was for training qualification against the name of the petitioner, it was shown blank. But in this case, that issue is not raised.
Lordship, initially lordship decided that yes, if they are subsequently trained and they are getting A category and 1416 batch, if they are treated as a train, so you should correct the records and the single order has been passed by the other single page. But subsequently lordship in this order, lordship has changed lordship mind. Then as because they joined as an untrained, they were in untrained panel.
Just a minute, let me go through my own. You are also selected in 2016 selection process.
Yes.
When you were appointed, February 2017?
No, I was appointed in 2018. But date is 3rd October 2018. I joined.
3rd October 2018.
28.
What is the date of issue of DLED qualification certificate?
Certificate was issued on 2nd July 2019. Page 15. Right, sorry, madam, I'm sorry. Delayed certificate was issued. No, I haven't. Paragraph 7 I have stated.
Document is submitted.
So where is the document?
Paragraph 7 I have specifically stated the delayed certificate was issued on 22nd April 2019.
But this court proceeded on the basis in that writ petition that it's a case of uh, changing the score by allotting marks against training qualification. But that list is not an issue. Here issue is that the petitioner was not a petitioner subsequently obtained training qualification for the session 2016-18. Now petitioner was appointed in the selection process in 2016. So in 20 and the session was 2016-18.
The year was 2016. So in 18 they passed.
Before joining.
But in other matters, in connection with
list
the session 2014-2016, I have held in other matters, you would find that due to delay made in issuing certificate, petitioner should not suffer. But in the present case, position is different. You are not a candidate in connection with 2014-2016 session.
No.
You are a candidate in connection with 2016 to 2018 session. But you are appointed in 2016. At that point of time, you are not a trained candidate. You are not a trained candidate.
I'm not trained candidate.
Then, and there was no question of delay in issuing certificate.
No, my case is not that.
And you applied as an untrained candidate. So how this order will help you?
Manad, on 2nd July 2019, A category scale was paid to me. Issued to me.
That is in since you have obtained the qualification, DLED qualification.
So the board has recognized my training qualification, and my lord, for training I am getting the scale.
Board is no one to recognize lordship. Board after recommendation appointing authority is the DPS and the state.
Try to appreciate the position. You are selected and you are appointed as a primary teacher on 3rd of October 2018 in connection with 2016 selection process. Admittedly, you participated in the selection process as an untrained candidate.
Yes.
Subsequently, you enrolled yourself in a training qualification training course for the session 2016-2018.
Yes.
Now, after 2018, when the examination, when the result was published, 22nd of April 2019, you are already an appointed candidate. Now, if you are an appointed candidate on 22nd April 2019, how you can be treated as a trained candidate in connection with 2016 selection
I'm
process?
not praying that. My prayer is not that. My prayer is that, my lord, since A category scale was given to me for having training qualification, as of now, the board should correct their database by treating me as the trained candidate. Only this is, kindly see my prayer, ma'am. No,
What database?
2016 I'm not praying
What
for
database? What database?
My lord, the
You obtained qualification, got the scale.
yes.
Matter ends. What database is to be corrected? What database is to be corrected, Mr. Hussain?
But initially the database was untrained because I was appointed as untrained.
You have appointed as an untrained, you will remain as untrained. So, in connection with your training qualification, subsequently, when you obtain the training qualification, you obtain B.Ed qualification. You obtain A category scale of pay. Matter ends. What database is to be corrected?
But the board's database says that we are untrained candidates.
At the time of your appointment.
At the time of appointment. But board also incorporate this that during the service period they have qualified training qualification. Presently they are trained. Only this endorsement in their record.
But that is not in connection with your in connection with the relevant selection process of 2016.
No.
At present, petitioner ought to be treated as.
Board has nothing, no role to play. It is the DPS is the appointing authority and state is paying them.
So DPSC is the authority. DPSC is not represented today. Who is appearing for Birbhum DPSC? So you are also appearing for DPSC. So I'll direct the DPSC to treat the petitioner as trained candidate subsequent to obtaining DLED qualification. Yes.
DPS.
Yes. But not in connection with the
It cannot be.
That is in a separate situation. Court passed an order. 2016 and 2016 selection process due to delay cost, petitioner suffered.
Yes. That is not my case.
Petitioner affidavit of service, file your affidavit of service. Yes, yes, filed previously. It was
Yes,
filed.
yes.
Affidavit of service filed or na? Petitioner participated in the recruitment process of 2016 for appointment in the post of primary teachers and got selected. Subsequently, petitioner was appointed as primary teacher on 3rd October 2018. It is submitted by the learned advocate representing the petitioner that petitioner took admission in DLED course for the session 2016-2018 and on successful completion of said course, petitioner was awarded certificate on 22nd April 2019. In recognition of petitioner's training qualification, she was sanctioned A category scale of pay. Stop. Petitioner prays for direction upon the concerned respondent authorities to treat her from the date of issuance of training certificate, that is 22nd April 2019, as trained candidate. Stop. Next paragraph. Respondents are represented by learned advocates who have jointly submitted that at the time of participation in 2016 recruitment process, petitioner was untrained and petitioner offered candidature as untrained candidate. Subsequently, subsequent to appointment of the petitioner, she obtained training qualification and certificate was issued on 22nd April 2019. In consideration of obtaining training qualification, petitioner was granted A category scale of pay. But it is contended that petitioner may not be treated as trained candidate in connection with the selection process, which was where in connection with the selection process of 2016, where petitioner participated. Next paragraph, having considered the submissions made on behalf of the parties, it appears that petitioner participated in 2016 recruitment process as untrained candidate and on being selected, joined the post of primary teacher on 3rd October 2018. Stop. Petitioner took admission in DLED course for the session 2016-2018 and after successfully completing the said course, petitioner was awarded certificate on 22nd April 2019. Stop. Based on training qualification, petitioner was sanctioned A category scale of pay. Next paragraph. In view of aforesaid situation, though petitioner may not be treated as a trained candidate in the selection process of 2016, but in view of obtaining training qualification by issuing certificate in her favor on 22nd April 2019, she should be considered as a trained candidate from the date of issuance of certificate relating to DLED course. Next paragraph. With the aforesaid observation, writ petition stands disposed of.
I'm grateful.
Item number 100.
For transfer my lord on general. My application is page 20.
Who is appearing for the respondents? DPSC, inter-district transfer. So DPSC is the authority. Where
DPSC is the
transfer
authority,
application?
Page 24, Lordship. দাদা এক মিনিট কত টাকা করি এই ডিপিএসসি খেলে
21,213 কোথায়? 21,213 ওগুলো তাহলে থাকবে, সব উল্টো পাল্টা হয়ে আছে।
So your prayer for transfer is on the ground of surplus teacher.
Let it be verified and we will step according, take steps according.
Affidavit of service. Affidavit of service, yes, previously it was filed. Affidavit of service. Petitioner prays for transfer, being a primary teacher working under District Primary School Council, Birbhum. In support of such prayer, notice of this court is drawn to transfer application dated 15th March 2025, which is at page 24 of the writ petition, wherefrom it appears that petitioner, being surplus teacher, made such application for transfer. Stop. It is also submitted that petitioner has completed 5 years of confirmed service as primary teacher. Therefore, under relevant transfer rules, there is no impediment in transferring the petitioner from one primary school to another primary school in the district of Birbhum. Next paragraph. Birbhum District Primary School Council is represented by learned advocate who submits, since issue is pending before the chairman, comma, same may be directed in accordance with the same may the application for transfer of the petitioner may be considered in accordance with law. Next paragraph. Having considered the respective submissions made on behalf of the parties, writ petition stands disposed of, directing the chairman, District Primary School Council, Birbhum, being respondent number 6, to decide the transfer application of the petitioner dated 15th March 2025 by 6 weeks from the date of communication of this order, and decision to be taken shall be communicated to the petitioner by fortnight thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Writ petition stands disposed of. Urgent direction.
Grateful.
Item number 101.
I am for the board, Lordship.
I appear for the DPSC posting bottom.
Who is for the board?
I am for the board.
What is your instruction?
Lordship, this is for the medical ground they are asking for, Lordship. So let it be sent to the CM, Lordship, because the inter-district.
So therefore, the medical
chairman
report is to be obtained by
the lady working
in
over
which
there.
board, in which
District.
district you are you are working now?
Chairman put the joining কবে? 2010 joining.
So working in Purbo Bardhaman, you want to be you want to be transferred to a school in Paschim Bardhaman. So therefore, let the chairman Purbo Bardhaman District School Council obtain a medical. If medical report justifies transfer of the petitioner, then it is to be forwarded to the secretary. No, Secretary West Bengal Board of Primary Education. Who shall take decision based on medical report?
Not only the medical report, the district she wants to go, that chairman has also to be called for by the secretary to whether that can be accommodated.
So take the suggestions and views of the chairman District Primary School Council Paschim Bardhaman and then take decision.
Lordship.
Where is your transfer application?
Transfer application, page 27. Lordship, one more thing.
But you have
medical is a
transfer on
father's
of your father.
Fathers.
You have not stated what is your ailment. Nothing. আমি নিজেও অসুস্থ।
বলতে যাচ্ছিলাম
Where
বলতে
you
তো
have stated?
মাফ করছি আমি যখন বলে যাচ্ছি যে
Writ petition will not do. Transfer application is to be considered. Where is the application? Appropriate application disclosing the ailment, nature of ailment you are suffering.
আমি বলতে যাচ্ছিলাম যে বাবারটা দিয়েছে
No, that is not an application at all.
Per se, the writ petition also does not suggest that.
Because under the rules, there are specific categories of illness which can be considered unless until suppose you are suffering from a disease which is not a notified disease. As per the relevant transfer rules, you are not entitled. I will not consider, I will consider first your application. You have to make a fresh application. It's a vague application. It is, please read Bengali document, page 27, so that we can understand what is the nature of the transfer application made on medical ground.
And also,
আমার বাবার বয়স ৭৮ বছর, বিগত 5 বছর ধরে তিনি অসুস্থ এবং পঙ্গু ও শয্যাশায়ী। বর্তমানে তার ব্রেন সেল ক্ষতিগ্রস্ত হয়ে যাচ্ছে, তাকে দেখাশোনার দায়িত্ব আমার। রোজ 160 কিলোমিটার যাতায়াত করবার সেবা করার আমার পক্ষে খুবই কষ্টসাধ্য হয়ে পড়ছে। আমি নিজেও অসুস্থ ও দুর্বল। Father's illness is not a ground. It is the teacher, spouse and children.
না
Sorry.
Second point also, it shows surplus teacher is one of the points.
Petitioner prays for mandamus, giving direction. Here the order, giving direction upon the concerned respondents to transfer him from his present primary school in Purbo Medinipur, Purbo Bardhaman, in Purbo Bardhaman, to another primary school in Paschim Bardhaman, since petitioner is permanent resident of Paschim Bardhaman. Stop. It is submitted by the learned advocate representing the petitioner that transfer application dated 27th March 2025 is made on medical ground since petitioner is suffering from ailments. Next paragraph. Respondents are represented by learned advocates. Next paragraph. On perusal of application for transfer dated 27 March 2025, it appears primarily transfer application is made due to ailment of petitioner's father. Transfer application is silent as to nature of ailment petitioner is suffering from. Stop. In terms of relevant recruitment, in terms of relevant transfer rules, illness of father is not a ground to transfer the petitioner. To transfer an applicant teacher. Stop. Transfer on medical ground can only be made. Now, application for transfer on medical ground can only be made if applicant teacher or his spouse or children are suffering from specified disease. Stop. Next paragraph. Considering the transfer application dated 27 March 2025, no relief can be granted to the petitioner. Hence, writ petition stands dismissed. However, this order shall not preclude the petitioner to make application for transfer in accordance with law. Stop. Urgent job certificate copy.
Item number 102.
For the petitioner.
Follow.
Complete on all the
Nice.
when the next my friend had appeared and requested that also has been done. Lord, I'm totally ready with the matter. Only one brief is stuck in that thread. But I can assist my
Only thing is
the thief is stuck in the rain because of the rain. I can
not today.
No, I can because I the petitioner is really suffering. I'm so grateful. Thank you so much. I can. No, the petitioner was the teacher, my lord, assistant teacher, my lord. There was an allegation against the petitioner that some embezzlement of a sum of rupees 3 lakhs has been done by him. He was in charge of certain duties, and in that, for the purpose.
Who is appearing for the chairman, district primary school council, and the state? You are for the state.
Yes, ma'am. Now, my lord, that allegation came, my lord. After that allegation was levied against me, I was sacked, my lord. I was suspended. Thereafter, there was an FIR that was.
Now, whether the petitioner was under suspension.
No, my lord. Petitioner service has been terminated. In that 2015, he has not challenged the order of termination. After the acquittal, he prayed to join his service. It cannot be. He has to challenge that order.
Well, there was a writ petition earlier. Writ petition. I'll just indicate.
No, but if only ground is involvement in a criminal case, and petitioner was terminated, and if petitioner is subsequently acquitted, then why petitioner's case will not be considered?
Well, what happened, my lord?
They will file your affidavits.
My lord, I do admit it's a lacuna on the part of the chairman, and it should be order of suspension.
Let the be admitted. File your affidavit. Where is the order of termination?
The order of.
My lord, page 16.
Page 16.
16.
And operative portion is page 70.
16.
An operative portion, page 70.
Thereafter, my acquittal is from page 20, and the relevant portion is at page number 35.
Well, two grounds are there. One is unauthorized.
Just a minute. Matter referred to disciplinary committee for future action. So, what action you have taken?
My lord, the disqualification.
No, for future action, what action you have taken after acquittal?
No action.
So take a decision. Take a decision.
Man. But only standing in the way of
Come to page 17, Mr. Das.
Only
second paragraph.
two grounds.
Having considered the facts and read it.
Having considered
Paragraph 2 of the government notification dated 17th May 1975, where released are unconditionally should be sanctioned only after such unconditional release, special leave with full pay for respective periods of detention, and those who are discharged should also be reinstated in their respective posts subject to the condition that a teacher concerned had not been detained or period of exceeding 12 years.
Our order was passed in a two grounds.
Matter referred to disciplinary committee for future action. What was the steps taken by the disciplinary committee?
No steps. Since the matter is pending, no steps has been taken.
And where is the order of acquittal?
Page number. It starts from page number.
Page 40. Page 35 is the operative
relevant
portion.
The order starts on page 18. Relevant portion.
Page?
Page 35 is the relevant portion of the order of the judgment. That the accused person, namely Dipender Narayan Das, is found not guilty for the offence, and as such he is acquitted from this case.
Primary teacher. Issue.
My lord, one thing, my lord, the order was been passed on the two ground.
Matter
Number
is
one,
heard in presence of the learned advocates representing the petitioner and South 20 and represent the petitioner and District Primary School Council South 24 Parganas. Stop. It is submitted by the learned advocate representing the petitioner that petitioner was implicated in a criminal case being Kulpi PS case number 124 dated 15th May 2010 on the on charge of defalcation of fund. Stop. It is also stop. However, criminal proceeding was culminated into an order of acquittal with a judgment dated 5th September 2023. Stop. It is further contended that no formal disciplinary proceeding was initiated against the petitioner and action taken against the petitioner thereby not permitting him to resume duty entirely rests on criminal proceedings. Stop. When order of acquittal stop. After judgment was delivered by the court, thereby acquitting the petitioner of charges, with a judgment dated 5th September 2023, petitioner is entitled to resume duty as it is submitted by the learned advocate or as it is submitted on behalf of the petitioner.
Also, one more.
Next paragraph. Mr. Das, learned advocate representing District Primary School Council South 24 Parganas, has made submission based on order dated 19 January 2015, passed by the chairman District Primary School Council South 24 Parganas, being respondent number 4. Stop. It is submitted that order was passed by the respondent number 4 far back on 19 January 2015, but contemporaneously said order was not challenged. Next paragraph. However, on perusal of the order dated 19 January 2015, it appears that the order was not conclusive. Rather, issue was referred to the disciplinary committee for future action. It is submitted on behalf of District Primary School Council South 24 Parganas that no subsequent steps were taken by the disciplinary committee against the petitioner due to pendency of criminal proceedings against him. Next paragraph. Since criminal proceedings has culminated into order of acquittal as it appears from the judgment dated 5th September 2023, respondent number 4 is directed to take final decision on the final decision relating to service of the petitioner, keeping in view of the fact that no formal proceeding has been initiated or no formal proceeding has been drawn up against the petitioner in terms of relevant service rules. Next paragraph. Decision stop. Respondent number 4 is directed to take such decision within a period of 4 weeks from the date of communication of this order, and same shall be communicated to the petitioner by 10 days thereafter. Before taking such decision, respondent number 4 shall be granted opportunity of hearing. Next, before taking such decision, ki bollam? Bhul bollam. Before, shall be granted opportunity of hearing, and a reasoned order shall be passed. Next paragraph, writ petition stands disposed of, urgent xerox.
May I have the liberty to raise the point of allowance and payment because of the same government notification clause?
Next matter. আচ্ছা এবারে দেখি ওই ফিক্স ম্যাটারটা কি হয় দেখি whether 3 p.m. matters all parties are present today. Who is appearing for the petitioners?
Engage court number 18.
That matter appeal is going. Where is Mr. Bandyopadhyay? Then let me adjourn this matter and fix it up after 2nd of August because this court is not available from 19. Next week is not possible. 2 other hearing matters are fixed. So this court will not be available from 21st of July for a period of 2 weeks. So I'm fixing after 2nd of August.
But if
call the fixed matter.
it was fixed for Dr.
All are engaged in that matter before the division bench.
If Dr. Patra could have concluded, we could have.
First, I want to dispose of the matter which I have heard where Mr. Vishwarup Bhattacharya was appearing on behalf of the petitioner regarding that is the first matter.
Eligibility obtained after cutoff date.
Item number 3152336.
Your 9.
309 কি আছে?
If petitioners are ready, I am ready. Everything rests on this notification dated 23rd of September 2016. That is relating to the service of the teachers working in school. So, and Mr. Dr. Patra has pointed out in connection with observations made by the coordinate bench in the judgment, which is at page 44 of the affidavit in opposition, where it has been clarified. In connection with clause 3 of the advertisement and the relevant rules, third proviso to rule 4. 4.1. What is the scope of relaxation after the observation made by the coordinate bench in the judgment, which is annexed to the affidavit in opposition?
Clause 10.5 and 10.8 of the advertisement as well.
Yes. Yes.
Today.
First of all, 3rd August 2017 does not come in aid of the petitioner in the matter of treating them as trained candidate, because the purpose of this notification of MHRD is completely different. And in addition thereto, in the judgment dated 11th December 2020, come to page 44. And the observation at page 45. Both the, first of all, clause 3 of the recruitment notification and third proviso to rule 4.1, which says provided also that the certificate received on or after the last date of the application and mentioned in the application form shall be counted for academic and they provided that the certificates received on or before the last date of the application and mentioned in the application form shall be counted on.
And mentioning is very important.
And then the observation of the court.
Kindly fix the matter.
Mr. Bhattacharya is here, Miller.
We have made our submission.
Let commission commence.
Let the commission commence.
Very well.
I'll come. The portal number 8.
Yes,
the last portion, I'll just come. And when the judgment will be dictated,
Just give me 10-15 minutes.
Then let me fix up this matter after 2nd of August. Let me take up the motions today after 2nd of August. Come back. I have heard you. I will hear Mr. Dr. Patra on the next date. Esho. You go and appear before the division bench, no issue.
Monthly.
Matters are taken up for consideration and fixed for matters are taken up for consideration. Stop. Stop. Consideration in presence of the learned advocates representing the parties. Stop. This is 21077 of 2023. The writ petition being WPA 21077 of 2023 within bracket Siddiq Sardar and others versus the state of West Bengal and others close bracket is also heard where Mr. Biswarup Bhattacharya, learned advocate, has concluded his submission. Mr. Biswarup Bhattacharya, learned advocate representing the petitioners, has concluded his submission. Stop. List the matters along with WPA 21077 of 2023. On 14th August 2025, for further consideration, when Dr. Patro, learned advocate representing West Bengal Central School Service Commission, shall advance argument on behalf of West Bengal Central School Service Commission. When Mr. Dr. Patro Now, for further consideration, when learned advocate representing the commission shall advance argument. Let the matters be listed under the same heading as 3 p.m. fixed matter. All are engaged there. Come back on the next one.
We are not receiving our appointments in this matter.
Yes.
That we are not receiving our appointments in this matter. So, some precedents.
So I am giving precedent. That's why matters are being fixed.
No.
Otherwise, hearing matter I am not touching. And that is on the mentioning of Dr. Patro, repeated mentioning. Otherwise, these matters would not have been listed.
Not have been listed.
Remember this.
22,618
After finishing of the motions, it is not possible for this court to touch the hearing matter. This court is not taking time. Yes. Yes. See the position of my list so far motions are concerned. Along with urgent matters relating to 30th May 2025 notification.
একটা ফাইল পাঠিয়ে দে
Yes, next matter. Combined list ডাকবে তো এটা ওর সঙ্গে থাকবে, ফাইলের সঙ্গে ওটা থাকবে, এই সিদ্দিক সর্দারের সঙ্গে ওটা থাকবে। State.
আমি কিছু করতে পারবো।
Item number 1531 from monthly list of appellate side.
Peter and very below of this is husband. The widow of it, this is teacher, my lord, was appointed in the year 1969. And staff, my lord, up to 8th of January 1981. Thereafter, he was transferred to another school. After joining of the he had to take therefore, we compelled him to obtain medical leave for 4 years. And thereafter,
When petitioner retired, husband of the petitioner. When retired?
in 2007. This is the third round of litigation. Practically fourth round on appeal. Then, since 1985, petitioner made several representations before the school authority as well as the sub-inspector of school for regarding his joint.
So on the last date of his service period, he was not in the school.
Not able to attend the school.
Let it be decided on affidavit.
This is
No.
This is
But Lordship, he has a Lordship 40 years absent from the ECS. Kindly see the DI report.
Kindly
2023 writ petition, sorry. Let it be decided on affidavit.
When retired? There was a direction of the division bench in this matter.
When retired? When retired?
Malad, kindly produce the division bench order. This writ petition was dismissed. That was challenged before the intra-court by.
That is not part of the record. No. Where is the order of the division bench in the writ petition?
Malad, I have given it.
Where is the order of the division bench?
Malad, I have given it.
July 24. Lord. Are you not ready with the matter?
I am ready. I have given this.
Where is your brief? So then, where is the order of the division bench?
I am mentioning this matter was dismissed. Subsequently, order of dismissal was challenged by filing an intra-court appeal. In intra-court appeal matter.
Where is the order of the appellate court?
My lord, this is the order, my lord.
It is not part of record.
How, my lord?
No, earlier writ petition was filed. Lord. They are the written back. This writ petition was dismissed for default.
Dismissed. Dismissed on merit.
On merit. 1531. Without affidavit, Lord, say how it is possible, Lord. Say without affidavit, he can't, Lord. Here, Lord.
Kindly produce the document.
Since the division bench has passed an order, absent from the 26 year from the school.
Who?
They
have restrained me.
As per the record of the, as per the direction of the High Court, Lordship, DI decided matter, Lordship. Page 17, Lord.
Kindly produce.
Yes, without.
Lord, I am even if I am entitled for the death gratuity as well as the area salary and provident fund.
July.
Board primary. I also appeared on behalf of the respondent authority. It is not the duty of the officer of the court. Yeah, I am appearing on behalf of the respondent authority only to oppose.
Why you are shouting?
My lord, kindly.
Why you are shouting?
Sorry, my lord.
Yes.
Sorry, my lord. I'm sorry.
I'll release the matter. If you go on, carry on like this. Please take your seat.
Vice Chancellor, you want to take it?
নিয়ে আসতে পারতিস, এটা এটা অনুষ্ঠানগুলো পড়ে আছে। তো ওই পয়েন্ট কেউ তো এই পয়েন্ট নিয়ে নেবো। আমি ক্যামেরা দেবো, কেন এখন দেবো না? তুই ক্যামেরা ওইটা নিচে পড়ে পড়বা। তুই সিরিয়াল 5 বছরে যদি আমি কন্টিনিউ অ্যাবসেন্ট থাকি অটোমেটিকটা বোর্ডের ওইটা আছে তো। কখনো আজকে নিনি বলে আজকে নেবো না, তো কোনো মানে নয় না, ওটা দেখালে হয়। স্কুল হেডমাস্টার ম্যানুয়াল বোর্ডেরটা আছে, হেডমাস্টার ম্যানুয়ালে পাবি, হেডমাস্টার ম্যানুয়ালে পাবি, এখানে পাবি না, এতে পাবি না।
So, Honorable Division Bench directed that the issue should be decided on merit. Now, the order was passed by the District Inspector School dated 10th of March 2023 is under challenge.
Yes,
Where is the order of the District
Page
Inspector?
79. Kindly. Everything is stated, ma'am. Page 70, P70. But I'm requesting your lordships kindly read from first page.
Yeah, total lordship, yeah, lordship.
It is very relevant.
Total paragraph is relevant, lords.
He was absent from 10th of May 1985 to 27th of February 2007.
Therefore, my lord,
Are you aware of the leave rules?
Yes, my lord. That was considered.
Continuous service
That was
5 years.
absence for more than 5
Terminate.
years. Please allow this court to respond. Continuous service for more than 5 years should be deemed, should be considered as a deemed
to terminate.
termination.
My lord, now, my lord, if your lordships kindly permit me to, my lord.
So can it be decided without calling for affidavits?
My lord, it has already.
Can it be decided without calling for affidavits when the Honorable Division Bench directed that a matter to be heard on merit?
Your lordships kindly,
Yes,
kindly bear me for 2 minutes, my lord. I can justify, my lord. That was considered, my lord.
Learned advocate representing the petitioner
My lord, kindly bear me for 5
has
minutes.
relied upon the judgment of the Honorable Division Bench dated 4th July 2024, passed on an intra-court appeal being MAT 641 of 2024, wherein order direction was given, wherein
My lord, my prayer is very limited,
whereby issue involved in this writ petition was remitted to the learned single judge to decide the writ petition on merit. Next paragraph. The writ petition is taken up for consideration wherein consideration, and it is found that the order of the District Inspector of Schools P.E. Howrah dated 10th March 2023 is under challenge. Stop. It appears from the state impugned order dated 10th March 2023 that petitioner remained absent from 22nd January 1981 to 9th of May 1985 and subsequently from 10th May 1985 to 27th February 2007.
when he was not allowed to join. Recorded.
Stop. Extent of break of service was found as 26 years, 1 month, 6 days. 26 years, 1 month, 6 days. Which, according to the concerned District Inspector of Schools, Primary P. Howrah, is required to be condoned for sanctioning retirement dues. Next paragraph. Issue involved in this writ petition needs to be decided on exchange of affidavits. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above. After the time fixed herein above for exchanging affidavit. Stop. The learned advocate for the petitioner is directed to communicate this order to the non-appearing respondents by 7 days from date and file further affidavit of service on the next day.
Next. Item number 1532.
Yes. Yes, appointed as primary teacher. 2012. Appointed. Yes.
Unsuccessful candidates while doing application can receive the preparation of the pen. But ultimately, this one of court but we are not parts.
Appointed in 2012. Then
Unsuccessful candidate appointed this one of court and ultimately they succeeded and this one of court directed the authority to give appointment to the candidates.
Unsuccessful candidate approached. Then those candidates were directed to be appointed. Yes. So how you are affected?
For giving appointment to those candidates,
You are excluded.
Yes, some candidates are excluded.
Your position in the merit list gone down.
Yes.
Yes.
Now, we approach this. Our service was terminated without giving any opportunity, without giving the
What opportunity of hearing in terms of the order of the court?
all those applications for those candidates approach this one ultimately decided the issue and set aside the admission and directed to reinstate. On a partial
When?
2020. Our service was terminated in 2016. Reinstated as on I had one petition. I am claiming the benefit of that.
Yes.
I am claiming benefit of that period.
Which period?
From 2016 to 2020. Because for no fault we have been done.
Show me the order by which you are reinstated. Order of the court.
Page 43.
Page
43.
পনেরো 21,207 এই
So based on judgment passed in Alauddin Mullah, Supra, this relief was granted.
Para 25. One para 25.
45.
20. Page 41, para 20.
Paragraph 25.
No, absolutely.
এটা রিলাই করছো পুরোটা
But your fixation after joining in terms of the order dated 24th of December 2019 was based on your previous appointments. So therefore, break of service has not been shown. So if you have not worked, how you will get the salary? Yes, notional benefit has been given to you.
Yes.
Just you have submitted that there is no break of service. I am asking you, when you joined the post in terms of the order dated 24 December 2019, then whether fixation was made by treating you as a first appointee or fixation was made in terms of your appointment in 2012. Then there is no question of notional benefit. Yes, because you have not worked for that period. How you can be given? What notional benefit? Notional benefits, when question would arise, if somebody is appointed in 2020, but he should have been appointed in 2012. But you worked in 2012, subsequently your service gone, then in 2020 you were appointed, and that appointment was in terms of the order dated 24th of December 2019. So therefore, question of notional benefit does not arise if you have been given pre-protection in reckoning your past service from 2012. I am asking you whether your fixation of pay in 2020 was in consideration of your past service, or you are treated as a fresh candidate.
No, past service, but excluding that 5 years period.
area actual service benefits you will not get.
I'm not claiming area, but my service area that 5 years period will be counted.
How? That has been counted. That has been counted. Fixation has been made. Yesho. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner was appointed. What is the first appointment letter? And what is the second appointment letter?
Page 70 is the first appointment letter of appointment. Page 70. Second appointment letter is page 46.
Page 17 is the first appointment. 19. 17 or 19?
17. In my free point is 17. 19 is a confirmation.
When you have joined 22nd of February 2022,
Yes, ma'am.
then when the petitioner subsequently appointed in terms of the order dated 2019,
Page 46.
Yes, ma'am. Page 46.
page 46 is the appointment letter.
Page July 2020. Page 2020.
And joined on 10 July 2020.
My lord, one thing I should indicate as the officer of this court.
Also the
Two of the Alauddin Mullah has indicated has been traveled up to division bench, and division bench decided that issue on the point that since you have not worked in that period will be no salary will be given to you. But if break of service is there, that should at the time of pension that would be counted as well.
Yes, but that is what I am also saying.
Yes.
This is
I am also saying.
exactly the view of your lordship.
That period is to be counted for all purposes,
Yes, ma'am.
but not area salary is not to.
Exactly, that is the view.
But I am not making much of area. That period should be counted in my salary.
That has been counted while fixing your pay. If past service has been reckoned, then it amounts to granting benefit.
Not
Issue.
possible that period, the gap, the 5 years gap, but I am entitled for that period, the customer benefit.
Petitioner was initially appointed. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. Next paragraph. Petitioner was initially appointed as primary teacher on 22nd February 2012. Stop.
আমার কাছে আছে হ্যাঁ এই তো।
Subsequently, service of the petitioner was terminated with effect from 1st August 2016. Vide memo dated 27 July 2016 issued by the chairman, District Primary School Council, South Kutupur, Paganas.
না নিল পুরো ইনস্ট্রাকশন
In order to accommodate some other candidates, stop. Order of or the memo dated 27 July 2016 was questioned by the petitioner in the writ petition being WPA 14970 of 2016, which was disposed of by a coordinate bench video order dated 24 December 2019. Stop. Placing reliance on judgment dated 29 June 2017, passed on 3 writ petitions, first one being WPA 4596 of 2017, within bracket Muhammad Alauddin Molla and others versus the state of West Bengal and others, close bracket. Coordinate bench directed the respondents to reinstate the petitioner and give similar benefits similar benefits in terms of the observations made in the judgment passed in Muhammad Alauddin Molla Supra. Stop. Next paragraph. In terms of the order dated 24 December 2019, petitioner was appointed vide memo dated 8 July 2020, issued by the chairman, South 24 Parganas District Primary School Council, and petitioner joined the post of primary teacher on 10 July 2020. Stop. Petitioner prays for notional benefits for the period from August 2016 till 9 July 2020.
He has prayed for arrears salary, my lord. Prayer, page 14, my lord.
He may have prayed for arrears salary, but now he is praying for.
Now he has submitted.
আচ্ছা কি বলছিলাম? Till 9 July 2020. Stop. Respondents, state respondents, next paragraph. State respondents and District Primary School Council, South 24 Parganas, are represented by learned advocates who have opposed the prayer of the petitioner. And it is also pointed out that petitioner has prayed for release of arrears salary. So it is submitted since petitioner did not discharge duty for the period from 1st August 2016 to 9 July 2020. She is not entitled to receive arrears salaries. Stop. Next paragraph. On query being posed to the learned advocate representing the petitioner, it is submitted that after resumption of duty by the petitioner on 10 July 2020, her pay was fixed, reckoning her past service with effect from February 2012. Stop. When fixation of pay of the petitioner is made on resumption of duty on 10 July 2020, taking into account her past service from 22nd February 2012, no further direction is required for granting notional benefits in favor of the petitioner. Stop. However, it is clarified that all future, it is clarified that for all purposes, service of the petitioner shall be reckoned from from 22nd February 2012, including calculation of pension. However, petitioner is not entitled to receive arrears salary for the period from 1st August 2016 till 9 July 2020. Next paragraph. Writ petition stands disposed of, urgent xerox. Let it be there. When you have submitted this order of the division bench, why you are taking back? Yes.
Item number 1533.
Let it be hard on a affidavit or let it be better. Petitioner has made a prayer. Now, on behalf of the petitioner, prayer is made for extension of time to file affidavit taking exception to the report filed on behalf of District Primary School Council, Poschim Medinipur.
Jhargram, my lord.
Or on behalf of District Primary School Council,
Jhargram.
Jhargram. So, time to file affidavit stands extended by 3 weeks. Next paragraph. List the matter under the heading hearing in the monthly combined list of September 2025.
Exception or
Affidavit taking exception. I have stated. Affidavit taking exception to the report filed on behalf of Jhargram DPS.
Yes. Koto number?
Yes.
Item number 1534.
হ্যাঁ আমাকে তো affidavit বলা আছে কিসের affidavit?
ও আপনি আছেন
কোনটায়?
এটা
না না না। Which for the petitioner?
সুব্রত ঘোষ।
At the time of call, no one appears for the petitioner and no accommodation is paid. However, state respondents are represented by learned advocate. Next paragraph. Writ petition stands dismissed for default. Parties to act on the follow.
Item number 1535.
Dismiss the explains that order and find that action could allow by appeal by the only class will make that order allow from appeal and directly the party from allow state of the consideration in respect of that period of day the will father had died.
To make
on it March 18, 2008. At that very point of
what
time,
was the direction of the appellate court?
the court directed father when his father had died at that matter of time what circumstances well that order and also father take consider in respect of the financial condition of the petitioner. Still treated in the petition is unrequired.
But the situation has been changed in view of the order judgment of the Supreme Court in NC Santosh Supra. That is not the law at present.
Here in this can you see the order of the transfer instruments 42.
In NC Santosh versus State of Karnataka, three-judge bench of the Supreme Court says that at the time of consideration of application seeking appointment on compassionate ground, what was the scheme that is to be considered? Previously in Canara Bank versus Mahesh Kumar, there was a direction and observation at the time of death of the employee, what was the situation prevailing that is to be considered. But now after the judgment in 2027 SCC 617 NC Santos, the situation has been changed. So on the date of considering your application, what is the scheme that is to be considered? The three judge bench judgment. Even if division bench is directed, before me Supreme Court judgment is there, and that is at highest strength, three judge bench judgment. Maybe, but I have to follow the law laid down by the Supreme Court. Whether the division bench has considered NC Santos, then read NC Santos, come back, take down the citation 2027 SCC 617, read paragraph 19.
Para 19.
If division bench would have directed taking into consideration the observation made in NC Santos, then question would have been different. Otherwise, on a similar issue, if a judgment is delivered by the division bench and another judgment by the Supreme Court, I have to follow the Supreme Court. Maybe. If you argue, then I will decide the issue. I will not hesitate. Yes. Previously, situation was in Canara Bank versus M. Mahesh Kumar. That was unsettled, and it was decided in NC Santos that what was the situation which was prevailing on the date of consideration, that scheme would be considered. At the time of call, yes. At the time of call, a matter is heard in presence of the learned advocates representing the parties. Matter relates to appointment on consideration. Matter relates to appointment under death in harness category. The question arises for consideration whether the scheme which was prevailing on the date of death of employee shall be applicable, or the scheme which was prevailing at the time of consideration of application seeking appointment under death in harness category shall be applicable. Stop. Next paragraph. Learned advocate representing the petitioner prays for accommodation to come better prepared. Next paragraph. List the matter under the same heading in the monthly combined list of August 2025.
Item number 1536.
I'm for secondary board, your lordship.
Recommended the name of the petitioner, the school service. But the school service council will have to issue appointment letter to the petitioner.
Who is happening for the service commission?
Troy is happening for this.
Where is he? He was there few minutes back. Well, not today. Not today. Because the commission has to be heard that why they are not recommending the petitioner for appointment. They are to recommend to the board, and board will issue appointment letter. So when the DI recommended for appointment on compassion ground to the commission.
Page 59.
You are for the state.
I am for the council because he was initially.
Where is this recommendation of the council?
Page 59.
59.
24th May 2023.
May 2023.
Yes.
Why for such a long time it is pending? Do you have any instruction? Let me pass an order directing the commission to file a report.
On last occasion, there was a direction to implement board as a party respondent, and today they are before.
Where the son has come.
Son.
Petition, father was a primary teacher.
Primary teacher.
Matter relates to appointment under date in harness category. Comma. Petitioner being son of deceased primary teacher made application for appointment. Stop. After processing the application seeking appointment under date in harness category, Chairman District Primary School Council or yes, Secretary Murshidabad District Primary School Council recommended to the Chairman West Bengal Regional School Service Commission Northern Region, Malda for appointment of the petitioner.
And page 60, that was also recommended by the DI secondary.
Stop.
Page 60, bottom right hand side.
Page 60.
Page 60, 60, bottom right hand side.
Stop. It is submitted on behalf of District Primary School Council, Murshidabad, that concerned District Inspector of Schools, AC Murshidabad, also recommended the case of the petitioner for appointment under date in harness category. Stop. Next paragraph. Petitioner prays for direction upon the West Bengal Central Schools, upon the concerned authority of West Bengal Regional School Service Commission, Northern Region, Malda, to take steps for appointment of the petitioner. Stop. Next paragraph. I think. Concerned authority of West Bengal Central School Service Commission is directed to file a report in the form of affidavit disclosing as to why till date petitioner has not been recommended to the West Bengal Board of Secondary Education for appointment on compulsion, for appointment under date in harness category. Stop. Let such affidavit be filed, or let such report be filed by weeks from date. List the matter under the same heading in the monthly combined list of August 2024.
Or directed the Central School Service Commission to file. But I think they are not the party. The Regional Service Commission is the only party.
Central Commission can file a report.
Yes, but they are not the party.
Regional School Service Commission is the party.
Yes.
Directing the concerned authority of
Respondent number 5 is there.
West Bengal Regional School Service Commission, Northern Region, to file a report in the form of affidavit. With a Central School Service Commission and West Bengal Regional School Service Commission, Northern Region.
Item number 1537.
The identical issue your lordship has already decided 2009 selection process of house. To pass the order in respect of house.
Bar Association rule number 16. I will direct you to serve him a notice because in the last occasion, when the matters were called on, this matter was called on, but no order was passed. Subsequent matter was called on. So that's why give a notice to Mr. Monojit Chatterjee, let him retain his position in the list, in the next monthly list. In the meantime, is servant.
I will.
There is a confusion whether any order was passed on this writ petition or not.
No, certainly.
Ultimately, seeing live streaming, it was found that the previous matter order was passed and a subsequent matter order was passed. This matter just passed on.
I will do that.
Yes. At the time of call, no one appears for the petitioner and no accommodation is spread for. You are for the board.
I am for the council.
Which council? However, however, District Primary School Council, Howrah, was Howrah is represented by Mr. Bishwas, learned advocate. Mr. Ratul Bishwas, learned advocate. Next paragraph. The learned advocate for Mr. Bishwas is directed. Mr. Ratul Bishwas is directed to serve notice enclosing copy of this order upon the learned advocate representing the petitioner by 7 days from date. Next paragraph. Let the matter retain its position in the monthly combined list of August 2020. এটা রাখার দরকার নেই। এটা রাখার দরকার নেই।
Item number 1538.
Yes.
And for the state, your lordship.
Paragraph
4. Page 3. That the petitioner of the father of the petitioner died on 19/11/2014, leaving behind him the petitioner as a nominee. The petitioner filed application for family pension for her favor in the next week of his death. As per directions of the respondent 2, and the same was deposited both in the office of the respondent 2 and 3. And the same was granted through PPO number such and such. Rupees the only malal, pre-malal interest on the biggest payment of area pension malal.
Who is for the state?
I'm for the state, your lordship.
Only interest on the delayed payment.
When you have retired 19 November 2014.
Yes, madam.
No. Petitioner died. Petitioner died on 19. Father of the petitioner died on 19 November 2014. Now, pension payment order was issued on 16th June 2023.
Yes, madam. 16th June paid, madam. I mean paying only interest.
When you have applied for pension?
Apply in the year of 2014, madam.
Show me the application.
Please, as per madam, the petitioner is a student, madam. He doesn't know anything.
Yes, sure. So let it be decided on affidavit. Petitioner has claimed file affidavit of service.
Yes, madam.
Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner has claimed interest on retirement dues, which was paid to him or which was paid to her due to death of her father on 19th November 2014. Stop. Father of the petitioner was a primary teacher.
Right.
Father was a primary teacher. Father of the petitioner was primary teacher. Stop. It is submitted that by issuing pension payment order dated 16 June 2023, terminal benefits including death gratuity was released in favor of the petitioner. But due to delay caused in releasing those benefits, petitioner claims interest. Next paragraph, state respondents are represented by learned advocate who has opposed the prayer of the petitioner. Next paragraph. in order to give direction upon the concerned state authorities to pay interest due to delayed payment of retirement dues after death of father of the petitioner. It is required to it needs to find out whether delay is attributable to the state authorities or not. Next paragraph. Let affidavit in opposition to this petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph. Petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. Next.
Item number 1539.
Payment of interest on the area. Malad knows very well, a director of pension and provident fund and group insurance papered an appeal.
Yes.
That Abhijit Boiddo case. He has referred Abhijit Boiddo.
What you are praying for? Pay interest on area pension.
Area pension.
So the appeal is pending.
Appeal is pending. That's why I'm.
Yes.
Ashun.
Can I take it next month, please?
Learned advocate representing the parties submit that on similar issue, appeal is pending before the Honorable Division. Let the matter appear under the heading motion primary in the monthly combined list of September 2025. Next.
Item number 1540.
I am for the TPS. These are all 2009 after Calcutta.
At the time of call, here for the Malda District Primary School Council. At the time of call, no one appears for the petitioner and no accommodation is paid for. However, District Primary School Council Malda is represented by learned advocate. Next paragraph. Read petition stands dismissed for default. Parties are to act on the server copy of this order duly downloaded from the official website of this school. Next.
Item number 1541.
I am for the district primary. Same issue. 2009.
You are for the petitioner?
Statement.
1541. Take it down. Yeah. Same order করে দেবেন, শুধু বলবেন যে District Primary School Council Malda and state respondents. Yeah, for the petitioner.
Next matter.
District Primary School Council Malda and state respondents are represented by learned. Therefore, dismiss for default, parties to act on the server copy.
Item number 1542.
Hello, I am for the Malda TPSC.
I am for the state.
Hello, it is not.
Which for the petitioner? Same thing.
No, it is not similar. They have A category. They are seeking A category from the date of examination.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, District Primary School Council Malda and state, you are for the state, Mr. Bari?
I'm for the state.
And the state respondents are represented by learned advocates. Next paragraph, read petition stands dismissed for default. Parties to act on the server copy. Next.
Item number 1543.
2009. No.
Yes.
2009, Malot after Calcutta.
At the time of call, one appears for the petition. The time of call, no one appears for the petitioner and no accommodation is paid for. However, District Primary School Council Malda and state respondents are represented by learned advocates. Next paragraph, writ petition stands dismissed for default. Parties are to act on the server copy of the order duly downloaded.
I'm getting it.
Next.
Item number 1544.
And for the district primary school boards.
Yes.
Last occasion, the direction for filing a report,
Yes, what is the matter about? Tell me. 2009 selection process, you were not successful. What remains?
I was not successful. I have made an application regarding my marks.
Under what provision the marks are required to be supplied to you?
The marks.
That the result has to be published under what provision? You participated in the selection process, you were unsuccessful. Under what provisions that the result is to be published by the authority? Is it an examination? It's an annual examination of the school or Madhyamik Parikha or higher secondary examination. Then? No. Under what provision in the recruitment rules? That the writ court extends this right. Under the recruitment rules, where is the provision? That all the marks of the unsuccessful candidates are to be notified. Show me.
Not all the marks.
2009 selection process, he was petitioner was not successful. What remains?
Yes. 2009 selection process. It was, my lord, moderate 2021.
Yes.
My lord, appointments were not 21. Appointments were given 2023. Thereafter, my lord, I made an application to know my marks.
Simple thing. Suppose 1 lakh candidates appeared or 50,000 candidates appears. Is a post is 10,000, 10 to 12,000.
Yes.
So in respect of 32,000 or 38,000 candidates, to all candidates, their marks are to be supplied by the district primary school council and the board.
No, my
Then
under the Right to Information Act, I have applied for.
yes.
They have to reply my letter.
They have replied. They have given your roll number.
No.
Yes, that is recorded in the order dated 2nd January 2025. Come to the order passed by the coordinate bench on 2nd January 2025. Said council by the impugned communication date has informed the petitioner that his roll number in the said selection was not matching. Mr. Vishwas, learned advocate for the petitioner, deferring to the admit card and the call letter relating to the the process submits that the roll number disclosed by the petitioner in his application under the said Act of 2005 was correct. Therefore, the ground.
2nd January 2025, but here they are supposed to file a report.
That I've seen. I'm not, I am on a different, I am on a different issue.
Yes. Malad, suppose Malad, only Malad, this.
50,000 candidates appeared against 12,000 vacancies. So in connection with 38,000 candidates, then the district primary school council will issue separate letters that you have received this marks in pedagogy, in this subject, in those subjects. So therefore you are not selected.
First of all, Malad, this is Malad, not 50,000 or 60,000 or 1 lakh. This is not first of all. Malad, it is Malad limited. Malad 10,000 or 12,000.
So think over it, come back on the next day.
Malad, Malad, what I paid Malad,
Let the matter in same position, not today. Come back. Please don't mention it. It's not the mentioning time.